Welcome to the August 23rd, 2021 Land Use Hearing Officer meeting. I'm Pamela Jo Hatley. I'll be presiding over the meeting this morning. If you will please stand as you're able for the Pledge of Allegiance. I pledge allegiance to the flag, States of America. Thank you all. Again, I'm Pamela Jo Hatley. I'll be the Land Use Hearing Officer this morning. Before we get started, I'll introduce Tom Hisney of the Development Services Department. He'll introduce staff and any agenda changes. Mr. Hisney?
Thank you, Ms. Hatley. My name is Tom Hisney, an executive planner with the Development Services Department. To my left, I have Carmen Mason. She is the hearing technician for this hearing. We will be joined virtually by a number of different planners with Development Services who will speak on the various cases. We are also going to be joined virtually by representatives of the county attorney's office.
All right, thank you. First of all, if anyone has any devices this morning that make noise, please silence those now. And do we want to address continuances now?
All right, we have some changes to the agenda. I'm going to read into the record. Agenda page 4, item A3, special use application 21-0743. Applicant is the Padilla School of Tampa Bay Incorporated. This application has been withdrawn by the petitioner.
All right, and did we have, do we want to address a continuance?
Well, in a minute. Yes. Did you want to ask if anyone had been interested in the Padilla School?
We have to do that. Okay, yes. Is there anyone here to speak on this item? This is special use 21-0743, item A3 on the agenda. Is there anyone here to speak on this item? Okay, so this one has been withdrawn?
Yes, ma'am.
Okay.
All right, our next change to the agenda is on agenda page 9, item J1, special use application 21-0606. The applicant is Dune, Florida Land One Sub LLC and South Shore Bay Club LLC. The applicant is requesting a continuance to the October 25th Land Use Hearing Officer meeting. However, this request was not made in a timely fashion, so they need to request it now to the hearing officer.
All right, this is, the applicant is here. Thank you.
Good morning, Madam Hearing Officer. My name is John Grandoff. My address is Suite 3700 Bank of America Plaza. I'm here on behalf of Dune, Florida Land Sub LLC and South Shore Bay Club LLC. Respectfully requesting a continuance until the October 25 hearing at 10 o'clock a.m. The reason for the continuance is that we need to realign the legal description to match up with a pending major modification to the plan development, which I've discussed at length with Mr. Hisney and also with Mr. Hisney's staff, including Mr. Steve Beachy. And we requestfully submit to you that there are grounds for the continuance, and I do not believe that there is any interested parties that would object.
All right, thank you, Mr. Grandoff. All right, this is special use AB 21-0606. Is there anyone here to speak as a proponent or in opposition to continuance of this matter? Anyone here or online? Don't hear anyone? All right, so the continuance is granted to the October 25, 2021 Land Use Hearing Officer meeting.
At 10 a.m.
At 10 a.m., thank you. Okay. And that will close the hearing on 21-0606.
Thank you very much.
Thank you.
All right, that will then take us to the published continuances and agendas, which are as follows. Item A1, special use 21-0375. The applicant is Trademark Metals Recycling. This application is being continued by the applicant to the September 20, 2021 Land Use Hearing Officer meeting. Item A2, variance application 21-0532. The applicant is Nick Bracken. This application has been withdrawn by the petitioner. Item A3, that was just earlier it was announced that that case was withdrawn. Takes us to A4, variance application 21-0803. The applicant is Douglas Negron. This application is out of order to be heard and is being continued to the September 20, 2021 Land Use Hearing Officer meeting. Item A5, variance application 21-0838. The applicant is Sign Systems and Graphic Designs Incorporated. This application is out of order to be heard and is being continued to the September 20, 2021 Land Use Hearing Officer meeting. Item A6, variance application 21-0902. The applicant is David Wright. This application is being continued by the applicant to the September 20, 2021 Land Use Hearing Officer meeting. Variance application 21-0935. The applicant is Anthony and Britt Diaz. This application is out of order to be heard and is being continued to the September 20, 2021 Land Use Hearing Officer meeting. Application A8, item A8 rather, variance application 21-0938. The applicant is Dwayne Wilson. This application is being continued by staff to the September 20, 2021 Land Use Hearing Officer meeting. Item A9, variance application 21-0958. The applicant is RU Project Management Group, LLC. This application is being continued by the applicant to the September 20, 2021 Land Use Hearing Officer meeting. Item A10, special use application 21-1003. The applicant is Miguel Ramos. This application is out of order to be heard and is being continued to the September 20, 2021 Land Use Hearing Officer meeting. Item A11, special use application 21-1022. The applicant is Sushiyama Florida Incorporated. This application has been withdrawn by the petitioner. Item A12, variance application 21-1026. The applicant is Fletcher Professional Service Center, LLC. This application has been withdrawn by the petitioner, and that concludes the changes and continuances.
All right, thank you, Mr. Hisney. So moving on, I'm going to address some meeting procedures. First of all, remember to silence your devices. I already said that. The agenda this morning consists of items that require a public hearing by a hearing master. I will conduct a hearing on each item today and will submit a decision within 15 working days after the conclusion of today's public hearing. My decision will be filed with the clerk of the Board of County Commissioners. The hearings today will be informal. I will ask questions related to the scope of direct testimony and may call and question witnesses as I deem appropriate. I will decide all items of procedure or questions of procedure. I will take evidence, but will exclude evidence that is irrelevant, immaterial, or unduly repetitious. Evidence may be presented in written form, and all testimony shall be under oath. Hearsay evidence may be used to supplement or explain other evidence, but shall not be sufficient alone to support a finding of fact unless it would be admissible over objections in a civil court action. The order of presentation today shall be as follows. For variances, Mr. Hisney will call the case. Then County Development Services will have 5 minutes to present its report and findings. The applicant and the applicant's witnesses will have 15 minutes to present the proposal. Proponents will have 15 minutes to present arguments in support of the proposal. Opponents will have 15 minutes to present arguments against the proposal. County staff will have 5 minutes to present any amended findings or comments. And then the applicant will have 5 minutes for rebuttal and summation. For special uses, again, Mr. Hisney will call the case. The applicant and the applicant's witnesses will have 15 minutes to present the proposal. The County Development Services will have 5 minutes to present its report and findings. The Planning Commission will have 5 minutes to present its findings of compliance or non-compliance with the comprehensive plan. Proponents will have 15 minutes to present arguments in support of the proposal. Opponents will have 15 minutes to present arguments against the proposal. County staff will have 5 minutes to present any amended findings or comments, and the applicant will have 5 minutes for rebuttal and summation. The 15 minutes that are allotted to proponents and opponents is the total time among them. So if there are a number of persons who wish to speak, that time will be distributed among those persons. If there's anyone who wishes to speak as a spokesman for those proponents or opponents, you may designate that single spokesperson. When you come to the microphone today, please first state your name and address. The meeting is being recorded, so please speak into the microphone so your testimony can be recorded. When you're finished speaking, please see the clerk to my right to sign in for the record. Now we'll hear from the county attorney's office, who will state the legal requirements and procedures for appeal of a decision.
Thank you, Madam Hearing Officer. Cameron Clark, Assistant County Attorney. This land use hearing officer public hearing is for variance and special use requests. This is the time for interested parties to present evidence and testimony. Once the hearing officer has closed a case, the record of that case is also closed and no new evidence regarding that case may be submitted thereafter. Any decision by the hearing officer may be appealed to the Land Use Appeals Board. Should a decision of the hearing officer be appealed, the evidence and testimony that is presented at this public hearing shall be the only evidence that is subject to review by the Appeals Board. In reaching a final decision on petitions, the Appeals Board will only consider the decision of the hearing officer and the record that is made at today's public hearing. If an appeal is filed, the Appeals Board hearing shall consist of oral argument by the party appealing the decision, by county staff, and by any interveners, each of whom may be represented by legal counsel. The following shall stand to appeal a decision of the hearing officer or to intervene in an appeal. First is the applicant. Second is anyone who appeared before the hearing officer, presented testimony or other evidence, and is adversely affected by the decision of the hearing officer. It's the role of the County Attorney's Office to ensure that no new evidence or testimony is allowed before the Appeals Board that was not presented to the hearing officer at today's hearing. The County Attorney will recommend that the Appeals Board disregard evidence or testimony that is outside the record made at today's public hearing. Any evidence presented to the Appeals Board that is outside today's record could jeopardize the legality of the Appeals Board decision, and the presenter of that evidence could hurt his or her own cause. The safest course of action is to write any comments that you make today and to repeat those comments to the Appeals Board. Thank you.
All right, thank you. Again, all testimony taken today will be under oath. So if you plan to speak, please stand and raise your right hand if you're able, and I will swear you in. Those who are attending virtually, also please raise your hand to be sworn in. All right. Do you swear or affirm the testimony you are about to give is the truth, the whole truth, and nothing but the truth?
I do.
Thank you. All right, Mr. Hisney, please call the first case.
Okay. So on today's agenda, we have no vested rights cases, no fee waiver requests, and no remands, and no reconsideration requests, which then takes us to section F of our agenda, site development variances. First case is item F1, application 21-0940. The applicant is Furman Construction and Development Incorporation. They are requesting a variance to encroach into a required wetland setback. Staff findings will be presented by Ryan Joyce.
Hi, Ryan Joyce, Natural Resources. The applicant is requesting a variance from the 30-foot wetland conservation area setback requirement, section 4.01.07b of the Land Development Code. The applicant's specific request, as shown on the site plan submitted June 9th, 2021, is to allow for the placement of new pilings and fill material within the 30-foot wetland conservation area setback. Per LDC section 4.01.07b4, no filling, excavating, or placement of permanent structures or other impervious surfaces shall be allowed within a required 30-foot wetland conservation area setback. The applicant requests the placement of new pilings and fill material within the 30-foot wetland conservation area setback. The applicant requests a 23-foot 7 3/16 reduction of the setback to allow for a setback of 6 feet 4 13/16 inches. The findings. The home was originally constructed in 1963. A variance was granted previously, and that number is 98-0323 for the existing home's current encroachment into the wetland setback area. Encroachment for the home addition will not impact any additional wetland conservation area or wetland setback area. A second and third story addition is proposed over the existing footprint. That is all.
Thank you, Mr. Ryan. All right, is the applicant here?
Good morning. My name is Frank Furman, the owner of Furman Construction, and our architect Susan here is going to explain pretty much the variance.
Good morning. My name is Susan Elftman. I'm an architect. My business name is SE Architecture LLC, and I reside at 1296 Inverness Drive in Dunedin. Excuse me. We're requesting a variance to do additions to the existing home at 7905 Collie Road in Odessa. This is a lakefront property on Lake Hiawatha. It was originally constructed in 1963. It has a folio number of 100. It's one of the oldest properties in the county. So it predates any sort of zoning, setbacks, encroachments, FEMA standards, and we had to do a great deal of that when the current owner, Larry Sutton, bought the property. He's seeking to do a couple of things. The existing home, as was just mentioned, is already encroaching into the wetland setback. That was cured by variance in 1998. We are seeking to do additions above the existing building footprint of a second, so it's a split level, second story on part of the property and 3 stories on the other part of the property, overall not to exceed the zoning allowance of 35 feet. One of the problems with the existing home, it sits at 51.2 feet. Would you mind? Next slide. I'll just show you some of the existing conditions. So here's survey of the property. The yellow line shows you the existing wetland setback line. You can see the footprint of the existing house and the separate garage, 3-car garage structure further to the east of the property. Next slide. This is the existing house today. It's a little tough to see here, but the garage structure is immediately to your left. It sits at 54 feet elevation. The existing house sits at 51.2. So there's a step down from the garage to the existing house. And the grass field that you're seeing there is septic drain area and septic tanks. Next slide. This is that garage structure, separate garage structure. On the top left photo at 54 feet, the right photo shows how the property steps down from that to the existing house. These are taken from the surveyors when he surveyed and photographed the property. Next slide. This is the existing condition of the house, and you can see how close it is to the lake. There's an extensive wood dock structure that's been existing for many, many years. We're not proposing to change any of that. I just wanted to show you the condition. The wetland setback line is approximately at that tree line closest back to the house. You'll go to the next slide, please. Where the cypress stumps are there is approximately the wetland setback line. So next slide, please.
Okay, I'm sorry. Please go back to that one showing the cypress stumps. That's the wetland line?
Approximately. I'm going to show you a survey
Okay.
that I just wanted you to see the physical site,
Thank
but I'll
you.
show you the survey of the legal line. We had a new wetland delineation completed in December of 2020. So that's what we're going to see in the next
Okay.
site plan. Next one, please. Okay, so this is an old survey. The yellow line shows the wetland setback. This is from 1998 when the original variance was approved for the dark hashed area to the south of the property below where it says 1-story Mason residence. That was an addition completed in 2000, but at that time they cured the encroachment of the variance. The red line is the existing 30-foot setback. So you can see that half of the house is already encroaching. When we had the wetland setback line reset in December, I'm not sure if it's erosion or something changed with the line, but it's actually at the water line, so it appears a little further out than this current one. Okay, so here's the current survey. The yellow line is the most recent December 2020 wetland setback. The
Wetland or wetland setback?
sorry, wetland line.
Okay, thank
Excuse
you.
me. Setback line. So the footprint of the house does not change at all. What we're proposing to do is build 1 story over part of it and 2 stories over the other part to make the house habitable. It's currently 2,600 square feet. It will come in at just under 5,200 with the addition. So what we would like to do is maintain the existing footprint. The only part that will be added at the ground level is the red outlined area, which is on the front of the property. We're just putting a kind of a new entry and foyer. Part of that is to ease the transition from the garage. One of our limitations, as you can see, I highlighted in yellow, are the 2 septic fields. There's one between the garage, existing garage and house, and there's another one on the north side of the property. So we were kind of forced to go up, to go vertical. Next slide. This just shows you again that footprint for what we're proposing with roof plan and the differences in the elevations, the garage at 54 feet and the existing house at 51.2. The other part we're hoping to cure is the water intrusion and flooding when there are heavy rains on the property by elevating the finished floor above FEMA required with this addition. Next slide. Here's a section through the site. So the garage is on the left at 54 feet. The sloping line shows you the existing, the lower line shows you the existing finished floor of the house. And again, like I said, we're trying to elevate the existing finished floor so it's all flush. You'll note that the roof bearing line is right at 30 feet. We won't be exceeding the 35-foot allowance for zoning. Next slide. Just very quickly, the floor plans. This is the existing footprint with the exception of the foyer area towards the bottom of the drawing, which we're adding at that ground level. That's the only thing we're adding at that level. Next slide. Second level is the gray on the left. So the living area in the purple kind of to the right, that will be open 2 stories. And then 2 bedrooms on the left above the existing kitchen and dining area. Next slide. Third level master suite. This is above the 2-story living area with an outdoor master balcony. There's currently a steep roof overhang on the lake side. So the lake side would be the north, top of the drawing, which has columns existing carrying that. We're proposing to replace those with columns that will carry this balcony. So we're not adding anything that isn't already there. Mm-hmm. Next slide, please. Front elevation showing you intended look. Next slide. Lakeside elevation. So the 3rd floor on the left is that master balcony overlooking lake. Next slide. Site section again, just showing you some of the intended 2-story living space. Next slide. Again, just more structure of the house. Next slide. We did have a soil survey completed on the property. It was the opinion of the soil engineers that we can accomplish this with a slab on grade, not too deep foundation. We may need to do some auger-driven piles. That hasn't been fully engineered, but we did have our structural engineer lay out a schematic plan here, which is what this is. The intention is that should we need the auger-driven piles, those will be placed as needed with a grade beam tying them together, and then elevate the floor to get it up to the 54 feet. Next slide, please. Just some some renderings of the intended look of the finished project. I believe that's it.
All right, so just to clarify, please, you're not changing the actual footprint on the ground.
No.
You're adding stories to the house, and you're elevating the ground floor.
Correct.
Okay. And other than just replacing those columns, which are their existing columns, and those are, I guess, going into the same footprint?
Yes.
So I understand.
We will need to fortify the existing foundation, which will involve some digging of the existing to either drive the piles or put a stem wall footing to elevate the floor. That hasn't been fully engineered yet, but it is within the footprint of where there already is foundation.
Okay. All right, thank you. That's all my questions for you. Oh, please sign in with the clerk. And yes, thank you. All right, is there anyone here in attendance or online who wishes to speak as a proponent of this item, in support of this item? Don't see anyone. Is in support of this item? All right, please come forward. And we need your name and address.
My name is Larry Sutton. My address is 7905 Collie. I moved from Water Chase out into the garage apartment at the property. I'm a resident of Tampa, went to King High School, St. Pete College. All my kids grew up on a lake here, and they're all grown. I had 12 grandchildren. The oldest turned 15. The youngest just turned 3. He was adopted by my daughter from a heroin mom, and he just turned 3, and he's doing awesome and lovely. And I kind of want to give my grandkids the same lifestyle upbringing that their parents got. All my kids lived nearby, and so I wanted to relocate to a lake again and just kind of go through that with let the grandkids grow up the same way. Originally, I bought the property thinking I could just remodel the house. Unfortunately, it's been flooded several times, and we started finding a lot of damage in the walls, and so a simple remodel just kind of went out doesn't do any good. It's just going to go back again. So anyway, it's just want to let you know how this all came about, and that's pretty much all I have to say.
All right, and you are.
I'm sorry, both of my neighbors. I think they even sent letters in supporting it. Don't have any objections in the immediate at all. The neighbors are all about it and very gracious. And as a matter of fact, one neighbor is going to allow his property to be used as a staging. That's how cooperative the neighborhood is out there. So anyway, I just wanted to get on record and say those things.
Thank you very much.
Appreciate your consideration.
Yes, sir. Mr. Sutton, please sign in with the clerk. Thank you. All right, is there anyone here or online who wishes to speak in opposition to this item? All right, don't see anyone or hear anyone. County Development Services, anything further?
Nothing further.
Okay. And applicant, anything further? No, okay. Thank you. Then that will close the hearing on item 21-0940.
Our next case is item F2, variance application 21-1032. Applicant is Rodine Lake LLC, requesting a variance to encroach into the wetland setback area. Staff findings will be presented by Ryan Joyce.
Brian Joyce, Natural Resources. The applicant is requesting a variance from the 30-foot wetland conservation area setback requirement, section 4.01.07B of the Land Development Code. The applicant's specific request, as shown on the site plan submitted on July 1st, 2021, is to allow for lot development within the 30-foot wetland conservation area setback. For LDC section 4.01.07.B.4, no filling, excavating, or placement of permanent structures or other impervious surfaces shall be allowed within the required 30-foot wetland conservation area setback. The applicant requests construction of new home lots within the 30-foot wetland conservation area setback. The applicant requests an approximate 10-foot reduction of the setback to allow for an average setback of 20 feet. Findings are the proposed encroachment is approximately 33,940 square feet. A compensation planting plan has been submitted. The plantings are proposed to total 40,058 square feet. The compensation planting plan will be finalized at the subdivision construction plan review. A previous variance request for a 10-foot wetland setback, 21-0471, was denied. And that is all.
Thank you. All right, is the applicant here?
Good morning. Truett Gardner, 400 North Ashley Drive. I have the pleasure of representing Rodine Lake LLC. Presenting with me, I have Alex Shaler with my firm, as well as Abby Naylor, who's our environmental consultant. As mentioned, the request is to vary from the 30-foot wetland conservation area setback requirement. And as also mentioned, there was a prior request, but this plan has been completely reimagined to reduce the impact. Further, we believe what we'll be presenting today is a much more environmentally sensitive solution than what currently even exists on site today. We would like to note that we have no objections from any of the reviewing agencies, including Natural Resources and EPC. And with that, I'm going to turn over the presentation, which is a PowerPoint, to Alex Shaler and Abby Naylor, but we're happy to answer any questions you may have.
Thank you.
Good morning, Alex Shaler, 400 North Ashley Drive, Suite 1100 in Tampa. I'll let Abby introduce herself before I begin.
Hi, good morning. Abby Naylor, Naylor Environmental Solutions, 14706 Tudor Chase Drive, Tampa.
Perfect. So as Stuart kind of summarized in the beginning, we are here to represent Rodine Lake LLC, who's requesting a reduction in a setback for a wetland. So you can go ahead and go to the next slide. This is our project team. We'll skip ahead to the next slide on this one. So a little bit of background on this, as this was referenced in the staff report as well, there was an original variance that was submitted and denied back in April of this year, 2021. That was application 21-0471, despite a report of no objections from Development Services. Since April, we have taken into consideration all of the feedback from staff, have reviewed the original application as well as the opposition originally, and have completely, like Stuart mentioned, redone the application, redone the plans, and tried to come up with a solution that we feel is a reasonable request. And so the plans have been revised to reduce the setback reduction request. Now we're only requesting a reduction of 10 feet, providing a 20-foot setback on average, whereas the previous application requested a reduction of 20 feet, providing a 10-foot wetland setback on average. We have added compensation plantings, as the staff report referenced, as mitigation for the proposed impacts. And we have also secured Abby Naylor as an environmental consultant to make sure that we are not having any adverse effect on any wildlife currently out in the area. And today, like I said, our variance report is noting no objections from Development Services. Go to the next slide. Just some general site details so we can familiarize everybody with where this is actually located. This is between Gibsonton Drive and Big Bend Road, east of I-75. As you can see, the site is largely surrounded by residential single-family development. Next one. Our actual request today, as I've referenced in the background information, is a request of a reduction in setback from 30 feet to an average of approximately 20 feet, which is a 10-foot reduction, and that is that area shown in green on this plan. An important item to note, we have done some background research since our original application in order to kind of give everybody an idea of the precedent variances that have been approved in this area. So our subject site is the one starred, site number 1. As you can see south of Rodine Road, there's a host of different developments that have gotten approvals for wetland setbacks. And those setbacks, as I have mentioned in the PowerPoint slide, are for a reduction to a 10-foot setback. Like I said, our request is for a 20-foot setback. So we're providing even more than the precedent approvals in the area. You can go to the next. And just to summarize from our original application to our current application to give you an idea of everything that we've adjusted from the beginning. Like I said, our original setback request was for a 10-foot setback. We are now proposing an average 20-foot setback. We were providing 0 square footage of compensation plantings with our first application. We have taken into consideration the feedback from staff and understand that this is a very great mitigation option. And we have provided 40,058 square footage of compensation plantings for this development. You can go to the next one.
So in conjunction with McNeil Engineering, we came up with a planting plan that would be appropriate for the wetland that exists on site, which is a prior borrow pit. The plantings are all native. We are encroaching 33,940 square feet, and we're compensating a little over 40,000 square feet of those plantings. The way that we have selected the planting is to have more, wetland-dependent plants along the wetland edge, and then as you move up the slope, appropriate plantings that will actually not only be aesthetically pleasing but provide additional habitat for wildlife. You can go to the next slide. Right now, the existing condition on site, a lot of the shoreline is actually dominated by nuisance exotic species. Two dominant species are torpedo grass and Peruvian primrose willow. They're actually category 1 invasive plants. So with this plan, we're actually proposing to enhance the shoreline with native species. It'll actually provide some improved habitat for wildlife that may currently utilize the site. Everything we're doing out here on site is in compliance with the U.S. Fish and Wildlife Service and the Florida Fish and Wildlife Conservation Commission. So we're in compliance with their regulations in this proposal. One, I think, key item to point out, because this is a man-made borrow pit, the wetland line is defined as the top of bank. However, in reality, when you look at this graphic, the wetland line where wetland vegetation and hydrology starts is really about 15 feet down the bank. So even though we are asking for a 10-foot variance, there's actually 15 feet of upland that really exists between the top of bank and the wetland line. So overall, it really is a 35-foot buffer from the edge of the actual wetland where the line would be delineated if we weren't using a top of bank situation.
Okay, just slow down 1 second, make sure I understand.
Sure, of course.
So basically then from the actual water's edge, which we're looking at, up 15 feet, that's what you consider top of bank?
Correct.
And then does the 30-foot setback start at that point and go in 30 feet?
Correct.
Okay, thank you.
Correct.
Okay. Thank you.
You're welcome. That's all I have.
All right.
Yep, just to summarize, like Truett said, we're available for any questions, but that's it for us.
All right. I have a question related to once the property, if the variance is granted and the property is developed the way it's envisioned, what's to prevent the future property owners from removing those plants in the planting area? Is there any land use? Will there be any land use restriction there?
So as Ryan had mentioned in his staff report, that compensation planting plan will be attached to the permit. So that will require a permit revision if compensation plantings are changed in the future.
And property owners rarely see their permits or look at any of that. Will there be actually a restriction or a covenant or a conservation easement or anything?
Like I said, it'll be having been approved by EPC and Natural Resources. I don't know if there's any.
Okay.
I don't believe there's any.
So we don't know.
Conservation easement requirement.
All right, speak into the microphone, please, and state your name. So.
Yeah, sure. Abby Naylor.
Thank you.
There wouldn't be a conservation easement requirement, built into the requirement from EPC or Natural Resources, from my understanding. I was going to say, do you want to speak up? So I've been told we can add it to the HOA documents.
To the homeowner association. So the declaration of covenants will require
that the
protection
plantings stay in place.
Thank you very much.
Yep. Thank you.
All right, is there anyone in, and I'm sorry, we need you all, please, all three of you to sign in with the clerk.
Sure, yes.
Mr. Gardner, thank you.
And I just wanted to reiterate, we're happy to make that a condition of approval, the addition of that into the CCRs or the
Yes.
HOA documents.
Thank you very much.
Thank you.
All right, is there anyone here in attendance or online who wishes to speak in support of this application? All right, don't see anyone. Is there anyone here or online who wishes to speak in opposition to this application?
Yes.
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 All right, thank you. Those who are online who wish to speak in opposition, please state your name and your address and then continue.
Christine,
Go ahead, Christine.
Christine Hill, and my address is 11850 Whisper Creek Drive, Riverview, Florida, 33569. I live directly behind this setback that they are wishing to approve. I spoke up in disagreement with it the first time, and I stand my ground that I don't believe this is, you know, they say that this is a man-made borrow pit, but this was a man-made borrow pit 20 years ago, or well, 17 years ago. It is a flourishing, teeming wildlife lake now, and it overflows. So it goes all the way around the back of that inlet that they want to use, and it goes into the existing neighborhood, the Rivercrest neighborhood on the backside, which already overflows when we have heavy rains. It already floods back there when we have heavy rains. If you want to reduce the setback and reduce the area that water can go into, we're going to just continually overflow the already existing subdivision. If they can't work with what's available, then perhaps they should look for a different plan. There's no need to encroach on the wildlife. They came through and mowed the brush, came with a brush trimmer to come through in in the heat of the drought that we had. That's when they took those pictures, by the way, of the 15-foot. It does usually sit much higher, and I have several pictures to show you that it sits much higher. But they came through and chopped down all the brush, and we had turtles and bunnies and birds and all kinds of wildlife floating back into our backyards because they're affecting the wildlife that already lives there, including gopher turtles. We have 2 gopher turtles that have been now moved out of there twice. There's no reason for this to continue, not to mention the impact that it has on us working from home with all of their construction vehicles behind us as well. Between the flooding and the erosion of the wildlife and the nuisance of having to live through their planning, I don't want a road behind my house. I don't want the wildlife gone, and I don't want the subdivision flooded. It's a terrible idea.
All right, thank you, Ms. Hill.
Yes. My name is Otis Colini. I also live in this subdivision. It's like she said, it is directly behind my house. What I want to do right now, if it's okay, I want to just share my screen so I can just show you some of those pictures that she's talking about. And I'm gonna just show you from our last meeting that we had, because I was there in the last meeting, just to show you the pictures last meeting and then show you the pictures today that I took this morning. So I just want to do that real quickly, if you guys will allow me to do that. Is that okay?
Yes, please.
Thank you so much. I appreciate that. So first and foremost, I'm going to share the screen. All right. So as you can see right here, this is what I showed last time when we had a meeting. As you can see that the water is low. This is during the time where, it's not much rain at all. You can see the sand here. You see the sand there. This is around the community. This is around where we live. This is pretty much me taking the picture. And as you can see, this is backyard. This is more so some of the pictures they were showing you guys. And as the reason why I'm showing these pictures is because I really want you to see that what you're seeing here is more so a neighborhood, a community already that does not need to be disturbed. Let me show you this. This is actually my backyard. This is actually me taking it from my screen and patio. And this is where they're proposing to add that 15 feet that they say that they actually have a clearance of 35 feet. But if you go a little bit further, you can really see that the water is just really there. But I want to show you how it looks today. Let me show you that, because I think that'll give you guys a great idea of what we're really looking at right now. All right. That's not it. Hold on. There we go. So this is what I took this morning. All right. So of course this is my backyard again, and this is the peninsula that they showed you in their schematics of how they're gonna add more land by taking away more water. This is actually and that's, like I said, this is a thriving community. I mean, you got people, this is somebody just fishing around 9:29 a.m. fishing in the back, and this is where more land is at. This is actually where we're pushing back the water and adding more land. This is exactly where you saw in the picture. That picture that they showed you is pretty much really behind my house. This is probably it right here, probably where they had the little orange little tape thing. This is probably almost that exact area, and this is somebody fishing right here. If I stood, I wouldn't be able to see this person, but I had to go from my bedroom window to see this because the person is so close to the land, because that area between the land and the water is just so, it has that little dip. And when you see this, and when you're talking about proposing to take more land away, I mean, to take away more water, you're taking away prime fishing spots. I mean, people frequently fish in this area. People frequently come and do activities with their family and their kayaks. And this is a Monday morning, somebody's kayaking, not the weekend. This is a Monday morning. And it seemed like he got something. So I also want to show you guys, of course, some of the wildlife. Now, like I said, like Christine said, this does expand around our whole entire Rivercrest community. And this is more, but I want to show you guys now that same area that I showed you from the first meeting, from the first meeting and the pictures that I opened up in this meeting. You can see that the sand no longer is, you no longer can see the sand anymore, because the water, we're just in the beginning of hurricane season and the water has already risen. You can see that. You can see that the water has already risen. Here is where me and my daughter just used to stand in the sand. No water. The water, wherever it's white or wherever you can see the sand, there was no water there. And we're just in the beginning season of hurricane season. And this right here is already showing you how the water comes up and how it does recede. If we take away more water by adding more dirt, more land, where does that water go? So, like Chrissy said, and honestly, this is actually more areas like all with this the bush, the grass, water grass bush is all area that me and my daughter used to just walk in, but we can't walk in it anymore because of course some of the rain and it hasn't even been consistent. Hasn't even been consistent rain. What happens when we get into the height of hurricane season and the water rise up like it normally does? So this is just to show you guys just more pictures of what it looks like in our area, in our community. And the reason why, let me stop sharing my screen. The reason why I bring this to you guys' attention, because, we're not just disrupting an ecosystem. I think ecosystems are important. I think it's awesome that they want to bring in brush and make sure that the plants that exist there will be there even when they bring in the other community in. I like that. But at the same time, I can tell you it was not their intent. Even Abby said there was no requirement. And then, of course, they quickly gather themselves and say, okay, yes, we can make it part of the HOA. But you can tell this is not their intent. I believe their intent is to simply build. And as community, as people in a community, our intent is to make sure that our community is safe, that it stays the same. And we're not against the building. Of course, the Rivercrest community has building all around it, but it's something else when we have it in our backyard. And it's something else when you have to remove wetland. when you have to remove wetland that's already in progress, that's already thriving, not just with the animals, but with the people themselves. And I think this right here is not just an encroachment on our lives, but also our recreation, not just our recreation, but also, like Christy said, you're talking about animals coming into your yard simply because they're being pushed out. This has to stop, and I think the committee made the right decision the first time, and I believe we should make the same decision the second time, even though hey, we're taking off 10 feet. Everything sounds so much better, but as you guys know, you heard it yourself, that you can tell it's not their intent. It's until they get a suggestion, they'll do it. Because their first priority is not to protect what's there. Their priority is to make money and to build these houses. And listen, I'm not against making money. I think making money is great, but at the same time, what is the cost? I always look at the cost. There has to be some level of dignity and integrity in what we do. And I'm just asking, not just me, but all of my community members. We are a thriving community and we don't want this. And they gave a picture, and here's how deceptive this is. They gave a picture of Lucaya. Lucaya is one community. One community. This is not Lucaya is one community with its own lake. They can encroach on that lake if they want to. It's their community.
Their lake is also enclosed.
Exactly. We are a community we are a community that's already established with other communities, and now this is a new community that's trying to take away what we already have. Nobody who has ever established himself around this lake has taken away from the lake. Not once, and you guys can review that. Not one person has taken away any wetland to build anything. And if they can't stop with the wetland, taking away the wetland, then they don't need to build. That should say something to us. If you have to take away wetland, then maybe you shouldn't be doing this. Maybe you're trying to add something that cannot fit. And I think that's what's going on. I understand profit, I get it. But can we please have a limit to what we do? Maybe we should reconsider. Go to a place that doesn't have that much people there, and you won't have to even require a permit for taking away wetland. That's all I have to say. And I want to say just thank you for this process and allow us to be heard. And we thank you for the first decision, because honestly, it lets us know as citizens and homeowners that we do have a voice, and we do have community leaders who do hear our voices. And I thank you guys for that. So thank you.
I'd also like to add that I submitted a petition from the neighborhood of those that line this back street. No, nobody is interested. We've all signed a petition not to have this come in. We just aren't all available on Monday mornings.
All right. Thank you, Ms. Hill, and thank you, Mr. Colomey.
Thank you.
Is there anyone else who wishes to speak in opposition to this item? All right. County Development Services, do you have anything further?
No, nothing further.
All right, Mr. Joyce. Applicant rebuttal.
Sure. Thank you again. Truett Gardner, 400 North Ashley Drive. We certainly appreciate the spirited comments and heartfelt comments from the neighbors. And in reimagining this project, those are the first things that we looked at. We wanted to leave this in a better place than where we found it now, or where we find it now. And so one, just wanted to clarify as it relates to the entitlements for the property. This is an approved PD. These lots are approved to go forward. And Ryan McNeil, who's the project civil, the two main things I heard from the residents, one were drainage and two, environmental. And so I thought we would address those once again. So Ryan McNeil, who's the civil, addressed the drainage issue. And I know Abby Naylor spoke before. She's our expert on the environmental side, which is a new addition to this project team. And so perhaps she can summarize just to get some clarification on the environmental impacts.
All right.
Good morning, Ms. Hatley. Chris McNeil, McNeil Engineering, 15957 North Florida Avenue, Luz, Florida. Regarding the stormwater, I just wanted to make the comment that we understand stormwater is a sensitive situation, as it is for almost every project in our area, and we're committed to making sure that we meet the requirements of Hillsborough County and SwiftMud as well, to show that we're not adversely affecting the neighbors in any way. Do you have any questions?
Mr. McNeil,
Yes.
Well, about the stormwater, will there be compensation on the property, or does the stormwater go into this water?
The
Area?
stormwater does ultimately go to the borrow pit as it was originally designed to. But we do have proposed retention ponds on site to compensate for the additional runoff. That's correct.
Are these properties in the flood zone area?
No, ma'am.
Okay.
And we're not proposing any impacts to the flood zone as part of the project either.
All right. Thank you, Mr. McNeil. That's all the questions I have for you.
Yes, ma'am.
Mr. McNeil, I need you to sign in.
Hi again, Abby Naylor. So just to address the wildlife on site, as I mentioned before, we are following all regulations from Florida Fish and Wildlife Conservation Commission, which is the state agency, as well as U.S. Fish and Wildlife Service. We are not impacting any of the wetland. Again, this is just for a variance to get a little bit closer to the and encroach just in the wetland setback. And those compensation plantings really are going to provide an enhanced environment for those species. Having additional plantings and then leaving also some open water in between those plantings not only provide areas for the birds and wildlife to forage, but then also provide some additional cover for them while they're foraging. So I think it's really going to be an enhanced environment that we're proposing.
Okay, Ms. Naylor, I believe one of the residents mentioned gopher turtles, which are actually tortoises. Are you an expert in wildlife?
I am,
and
yes.
habitat?
Yes, so a 100% gopher tortoise survey has not been completed to date, but that will be done prior to construction. And then for FWC, you can apply for a relocation permit and take those gopher tortoises to a recipient site if there are any to be found on site. And that's a very standard process that is part of the development process and approvals with FWC.
And Ms. Naylor, are gopher tortoises an upland species or a wetland species?
They are an upland species.
Thank
yes.
you. And I'm aware, of course, that the history of this water, it's a man-made water body, but those do attract birds and so forth,
Sure.
foraging birds and water birds. Is it, in your opinion, that from the top of bank, which is about 15 feet from the water edge, that top of bank and further in 20 feet, which will be the wetland setback area if this variance is granted, is that sufficient area as long as it's planted for those birds to have habitat?
Absolutely. In fact, the 10-foot of encroachment that we're requesting is all upland area, upland species, Bahia grass. So that area is actually not the area that most wading birds would be utilizing for foraging. They're going to be foraging down in the water. So that enhancement plan is actually going to help provide better habitat for them to forage.
All right, and if that area is planted properly, and if that planting is protected by covenants, is it your opinion that that will not affect the water quality and therefore the habitat for foraging?
Correct. I would say that having those additional plantings is going to provide a better habitat. Wetland plants are naturally, they uptake nutrients. So it actually is going to be an improved system. And as Mr. McNeil mentioned, there's stormwater treatment that will occur prior to any discharge into the borrow pit. So that would address water quality.
Okay, that's all the questions I have for you. Thank you.
Okay, thank you.
Mr. Gardner?
Yes, ma'am.
And it was mentioned that this is an approved plan development. And I'm just curious, I'm looking at the aerial of the property from the property appraiser's website.
Sure.
On my computer here. The narrow area leading from, I guess, the access road up to the broader area of land that goes out into the borrow pit. Will that narrow area there be just a road, or is it going to be developed with homes as well?
Just let me get Chris up here. Just I'm entering this late, but I believe that is just access.
Okay.
So let me make sure that's, yes, he's nodding affirmatively.
Okay. So that's just, it'll be an access road.
Yes, ma'am.
Are there encroachments there as well? Just
Yes, ma'am. There's a slight encroachment at the entry because as you can see, it's more of a flagpole lot. So the drive coming in where transportation wants us to place it then makes kind of a hard turn to the north. And that 90-degree area providing proper radiuses, we were able to avoid wetland impacts, but we do have a wetland setback reduction in there for a slight distance until we can get out of it.
I understand. Thank you.
Yes, ma'am.
That's all the questions I have. Does the applicant have anything further?
No, thank you for the opportunity to present this. And we did withdraw the application before, but hope you find that this is much more thoughtful, much more environmentally sensitive. And again, thank you for your time.
All right. Thank you. And then that will close the hearing on application 21-1032.
All right, that concludes section F. The agenda will take us to section G, which are sign variance requests. First item is G1, application 21-0914. The applicant is Ronald Fair. They're requesting a sign variance. Staff findings will be presented by Kim King.
Good morning, Kim King, Development Services. The applicant is requesting a variance for additional square footage and height for a pole sign located at 1616 Allison Woods Lane. Per section 70300C2A and B of the Land Development Code allows this parcel to have either 2 pole signs at 50 square feet per side, 100 square feet total, or 1 pole sign at 100 square feet per side, 200 square feet total, based on the street frontage shown on the site plan. Per section 70300C1A, no ground sign shall exceed 30 feet in height if located adjacent to an expressway or arterial highway. The applicant is requesting an additional 376 square feet of sign area, which would allow 576 square feet total for this pole sign. The second variance, the applicant is also requesting an additional 52 feet 4 inches of height, for a total of 82 feet 4 inches in height. This concludes my report.
Thank you, Ms. King. All right, is the applicant here?
Hi, good morning. My name is George Padilla, 1616 Allison Woods Lanes. I'm representing RAF Development, and I'm with AEC Services, the design consultant. This property was developed 2005 with a PD, I believe is what it was, and it's, I could use the overhead here. Okay. Just want to show you a couple pictures here and kind of walk in. Sorry, I should have told you earlier. Okay, so looking here at the set, right over here in this corner, right down in here, is where the sign will be located, we're proposing. There was an easement originally when it was designed that was created for a sign for the whole property. The original building was here. That's where AEC Services is, and the Friendly Plumber now resides in there. This was built later on. This became Scent Communication, and then later on it was sold off to a service company. Paul Davis Service is in here now. They occupy that whole building, and this parcel was sold off from RAF Development. Later on, this third phase here was there's a CrossFit gym, Sable Park CrossFit gym, and a stunt and tumble that was added in here. So what we're looking to do is add, since this road over here, Windhorse Road, dead ends up to 75, we're looking to get some signage for all the tenants that are in this business development. There's currently no signage on site, so we're trying to get some advertisement for these folks. So we wanted to put the sign in here, okay? Just to give you an idea of where we're located in the overall. 75 right down the middle. State Road 60 down to the south. And off the map slightly is I-4. So there's the location. The sign is going to be like right off the interstate there, meeting the setback requirements. One of the reasons for the height issues that we're having is that it abuts the DOT right away, and there's a lot of trees along in here. We've reached out to DOT to see if they could trim some of those trees or actually get them cut, but they have no plans on doing so at this time, hence why we're requiring the additional height, which then triggered the additional square footage of the face of the sign so people could actually see the sign because of the height. Along 75 here, there is obviously a lot of signs that are there now that abut their billboards and stuff like that. So we're just asking for be able to put a sign that'll be visible from the interstate for our current tenants that reside on the property.
Okay. That it? Thank you. Have no questions for you. Thank you. Please sign in with the clerk before you sit down.
Thank you.
All right. Is there anyone here in attendance or online in attendance who wishes to speak as a proponent of this request? Okay, don't see anyone. Is there anyone here or online who wishes to speak in opposition to this request? All right, don't see anyone. Development Services, anything further?
No, nothing further.
All right, thank you. And applicant, do you have anything else to add? No, okay, thank you. Then that closes the hearing on application 21-0914.
Our next case is item G2, variance application 21-0991. The applicant is Ed Morse of Mitsubishi Motors, requesting a sign variance. Staff findings will be presented by Kim King.
Kim King, Development Services. The applicant is requesting a setback variance for a monument sign identified as sign number 2 on the plan. This is an Ed Morse Cadillac dealership, and the variance being requested is for a Mitsubishi Motors sign located on the same parcel at 101 East Fletcher Avenue. The requested variance is for a monument sign previously approved, and they are replacing it in a new location on the parcel. The following is a list of petition numbers previously approved sign variances for this site. June 1986, petition number 166 by the Sign Appeals Board. July 2013, variance 13-0454, and January 2021, variance 21-0119 by the Land Use Hearing Officer. This sign was previously approved on the original variance from 1986, so they're just relocating it to this location. Per section 70300C1C of the Land Development Code requires monument signs at 4 feet high, a 15-foot setback from the right-of-way line, and for every 1 foot you increase the height, you must increase the setback 1 foot. The monument sign in this request is 29 feet 6 inches in height, which would require a 41-foot setback. The applicant is requesting a variance of 27 feet, which would place the monument sign at a 14-foot setback from the Florida Avenue right-of-way line. This concludes my report.
Thank you. All right, is the applicant here?
Good morning. I'm Mark Brenchley. My address is 3790 Beacon Ridge Way, Claremont, Florida. I was here in January, as Kim mentioned, and we received a variance for the sign. There was a problem in the determination of the right-of-way line and the property line at that time. It was actually 4 feet closer into the property than was originally determined in that application. So this is really another application seeking to move the sign that was approved in January 4 feet closer to the street to compensate for the error in measurement of the original. And so quickly, this is just to I'm going to be showing the sign as proposed, also as was approved in January. Thank you. Actually, it is the new standard national branding of Mitsubishi. Solid blade signs seem to be in now instead of a pole sign, as most ordinances throughout most jurisdictions throughout Florida and the nation are eliminating pole signs because of the unattractive lollipop look. And so this is the proposed. This is the sign that was there, as Kim mentioned, as part of the variance. And this is the same location that the sign is going to be installed at, only 4 feet closer, because this is a pole sign, and they proposed the foundation to be in the exact location, but of course, this is a wider sign, which required moving further toward the street of 4 feet. And then finally, it shows the enormous Ed Moore's property going from Fletcher on the north, Florida Avenue on the west, and then the interstate, I-275, and also Central Avenue on the east. So it's a huge property. And those signs, part of the variances that Kim mentioned, are trying to accommodate a very large site, also keeping in the, I think, the discretion of a better organized sign system that would allow the exposure, the identification, and being very reasonable in this case. All of the findings of fact have been shown to be correct and to be potentially approvable in this discretionary discussion and hearing. Any questions?
I have no questions for you, Mr. Branchley. Thank you. Be sure to
Thank you.
Sign in with the clerk. All right. Is there anyone here in attendance or online who wishes to speak as a proponent of this item? All right. Don't see anyone. Is there anyone here in attendance or online who wishes to speak in opposition to this item? All right. Don't hear anyone. Development services, anything further?
No, nothing further.
All right. And applicant, did you have anything further? No. Okay, thank you. All right, that closes the hearing then on variance 21-0991.
That concludes section G of the agenda. We'll now go to section H. These are general variances. First case is item H1, application 21-0853. The applicant is Wesley Harrell. They're requesting a variance to accessory structure requirements. Staff findings will be presented by Chris Grangillard.
Good morning.
Thank you. Go ahead.
Chris Grangillard, Planner Development Services. I'm here to present application variance 21-0853. The applicant is requesting a setback variance for an existing detached garage on a single family lot zoned RSC 6 with a mobile home overlay. Per LDC section 6.11.04.c.2, Accessory structures that are 15 feet or less in height may occupy required side yards, provided they are no closer to the street than any part of the principal building on the same lot, and any lot abutting said required side yard, and the structure is set back a minimum of 3 feet from the side lot line, including agricultural features such as eaves and gutters. In the subject case, the garage is closer to the street, Bella Vista Drive, than a portion of the single-family home on the lot, and therefore must meet the required side yard setback. Per LDC section 6.11 or 6.01.01, a minimum side yard setback of 7.5 feet is required in the RSC 6 district. The applicant requests a 5.2 foot reduction to the required side yard setback to allow a setback of 2.3 feet from the west lot line. Findings, the applicant states the garage is 12 feet in height. Also, per LDC section 6.01.01, minimum lot size of 7,000 square feet and minimum lot width of 70 feet is required in the RSC 6 district. Additionally, per LDC section 6.01.06, minimum lot size of 1/2 acre of upland is required for use of a septic system. The subject property is served by a septic system and is 0.26 acres in size, approximately. Therefore, it is non-conforming. However, it has been certified as a legally non-conforming lot per NCL 21-1023 in the case record. Also, the survey submitted by the applicant shows additional existing site nonconformities, which the applicant has elected to not address through the subject variance request. These include encroachments into a required 30-foot conservation area setback at the rear of the property, unless it is determined by natural resources staff that the setback is obviated by a seawall constructed with approval of appropriate regulatory agencies per LDC section 4.01.07.b. That concludes my staff report. I'll be glad to answer any questions you may have.
Thank you. I don't have any questions for you now. Applicant, please.
Yeah, I'm Wesley Harrell and reside at 9910 Ala Vista Drive, Gibsonton, Florida. I purchased this property many years ago, and the garage was there, and recently, I guess in the last 2 or 3 years, we saw it failing, and so we attempted to start a repair. As we got into the repair, as we got further and further, we ended up replacing the whole structure on part of the existing slab. Once we went for permitting, we found out that it could be in a floodway, so I hired an engineering firm. And after many months, they came back and said, look, okay, it's not. I got my certificate. Then, obviously, in the process, this variance came up. The structure that's there is an existing structure. The slab is in the same spot in relation to the property line. What we have done is we've put a nicer structure there. We've literally, the only thing different from the front of the property, it looks basically the same. From the side of the property, it looks basically the same, but the only thing is we had taken the back of it off. We moved it up just a bit, so it gave a better view of the water for my neighbors. So, and also too, when we started visiting this and looking, the odd shape and size of the lot, I looked and there's really no other place to put a garage. From my understanding, the garage had been there possibly 30 to 40 years. So I'm really not asking to do anything that hadn't been done there, with the exception of we moved it back, got the no rise certificate, and we'll have a nicer, better structure there. And as far as I know, I have a neighbor here with me that like to attest to that fact. But as far as I know, it's going to be a lot nicer situation there for the neighbors.
All right, Mr. Harrell, when did you say you acquired the property?
2003.
And the garage structure that was existing when you purchased the property, any idea when it was built?
The previous owners told me that it had been there when they purchased the property and they purchased it from the original. So I assume around 80, 78, 80, maybe. I don't know for sure. I'm guessing. But I know that I could tell it had been there quite a while when I purchased the property.
What's inside the garage structure? I mean, how is it built out? Does it have electricity? Does it have plumbing?
Has no plumbing. It would have minimal electric for a garage. I travel a lot and I'm there. I would leave a car and but no, there's no plumbing, no anything other than just really a garage space to hold more of a storage place, more or less.
So the original structure that was there, did you demolish that and rebuild it?
Yeah, we started out adding to it. And as we got into it, it was just, it was failing more than I believed it was. And I thought I could repair it and just leave it right where it was. But as we started getting into it, it just a little more came down a little more. So we ended up redoing the whole thing.
Mm-hmm. And what was the size of the original structure?
I'm not exactly sure. We extended it a few feet as we moved it away. We probably moved it away from the water, I'd say 15 feet or so, which luckily, because it was pretty close to being in the floodway, and they did the calculations on the whole thing. And so I was very happy about that. And I did that really for the neighbors when we talked about it, moving it up a little bit, because it gave them a much better view of the water. So it's a little larger, but it's on the existing, it's a little longer. It's on the existing, part of the existing slab. I still have part of the slab under it.
Mm-hmm. And you had to add some too, I suppose.
Yeah, we added some too, yes.
And what was the original structure? Was it wood or?
Yes, it was framed. It was framed.
And this one?
Same thing.
Okay.
Same thing.
Okay. And I think that's all my questions for you.
Okay, thank you very much.
All right, please sign in with the clerk here.
Okay.
All right, is there anyone here or online who wishes to speak as a proponent in support of this item?
Hi, good morning. My name is Dina Dunham. I live at 9903 Ala Vista Drive. I am actually the neighbor to the west of his property. And I just came in support of it. He is correct when he talks about how he moved it farther back from the water. It definitely gives my property a better view. My home actually sits back towards the road. And when he pulled the garage back, it actually did give me quite a bit more of the view of the water. So I certainly can't complain about that. So I'm totally in support of that. And on top of that, the structure that he, is speaking was originally, it was in very, very poor shape. And the work that he was doing, we were very excited to see. And we were in full support of it then. We're in full support of it now. And I think once he's done, it will certainly add value to our properties. That's pretty much it.
Ms. Dunham, how long have you been there?
We bought in March in 2020, but we knew the owners of the property. That's how we were lucky enough to find property on the water. We knew the previous owners, and they were actually very excited about the renovations on the garage also.
So you knew the previous owner of the subject property?
No, I knew the previous owner of my property.
Thank you for clarifying that.
Certainly.
Okay. All right. Thank you very much.
Thank you.
Anyone else here in support of this item? All right. Is there anyone here or online who wishes to speak in opposition to this item? All right. Don't hear any. Development Services, do you have anything further?
No, nothing further.
Okay. Applicant, anything additional to add? No. Okay. All right. Thank you. All right. This closes the hearing on application 21-0853.
Our next case is item H2. Variance application 21-0893. The applicant is Austin Coates. Request is a variance to accessory dwelling requirements. Staff findings will be presented by Tanya Chapella.
Good morning, Tanya Chapella, Development Services. The applicant is requesting a setback variance for a proposed accessory dwelling on a single-family lot zone RSC 3. Per the Land Development Code, sections 61102, accessory dwelling provisions, and 60101, lot development standards, accessory dwellings shall meet a minimum rear yard setback of 25 feet in the RSC 3 district. The applicant requests a 15-foot reduction to the required rear yard setback to allow a rear setback of 10 feet. The revised site plan submitted by the applicant shows the proposed accessory dwelling will be 900 square feet in size with a maximum height of 13 feet. This concludes my report. Thank you.
All right, thank you. Applicant?
My name is Gus Alcala, address 8220 Crenshaw Circle. My son-in-law will be talking for me.
Thank you.
My name is Greg Limpert. My address is 7612 Carrickle Court in Tampa, Florida. I'm speaking on behalf of my father-in-law, Gus Alcala, and his wife, Mary Lou Alcala. I have with me Joe Massacati from ACG.
My name is Joe Massacati, representing ACG Construction, 1302 North 23rd Street, Tampa.
Thank you. And before you speak, just state your name again, please.
My name is Greg Limpert.
Thank you.
I'm here, of course, for the setback for my father-in-law at his property located at 8220 Crenshaw Circle. He's currently looking to build an accessory dwelling on his home site in order for myself and my wife, his daughter, to come and help take care of his wife who has Alzheimer's disease. He is currently in recovery from a triple bypass surgery. So it makes it pretty hard for him to handle everything on a daily basis. Right now, we go there anywhere from 3 to 5 times a week at whatever hour he calls. It's approximately a 10 to 12 minute drive each way, and both of us are fully employed, so it gets kind of hard. He suggested that we build this on his property so that we can be on site to assist with her care. We're asking to put a 900 square foot secondary house, if you want to call it that, in the backyard with a height of approximately 15 foot to the top of the roof. The property is fully walled all the way around and sits on approximately 0.64 acres. I have the site plan here.
All right, speak into the microphone, and there's another one there. You may have to turn it on.
Okay.
Thank you.
It's a little small for you to see, but this would be the front of the front yard. This is the existing house with a screen porch and pool, and we were requesting put a small dwelling here. To the south of the house is your septic and drain fields, and to the north is the well. So this leaves us really the only area to be in. From our understanding, the current variances show that there's 7.5 feet on each side and 25-foot setback on the rear. So that's why we're requesting the additional 15 feet in order to put this secondary housing there. And that's pretty much it.
All right.
Oh, yes, we do have, yeah. I just had them. Oh, here they are. I have letters from all the neighbors surrounding him, including the head of the Pat Acres HOA, which is the neighborhood he lives in. All of them stating that they have no problem with it, and most of them actually recommending it. None of his neighbors have been around him for less than 20 years. Everybody knows everybody there. Everybody's close-knit, and everybody loves his wife and wants us there to help him take care of her. If you want these letters, I'm assuming most sent them to you, but if not, we actually have hard copies for you of all of them.
Yes, please put them in the record just to make sure. Thank you. And
You we give them to him?
Yes, right here. Thank you. Get to the clerk.
Okay.
All right. So the property is served by a septic tank
Yes, ma'am, it is.
and
Septic and well.
septic and well. And this is an accessory dwelling structure, so it will have plumbing, a bathroom, and electricity and so
Correct.
forth,
Yes, it will.
and a kitchen. All right. I
On the rear of the property, there is no utilities that run through the back. It has aerial electric, which runs from the front. On each of his neighbors to the south and to the north, their sides, it's everything 7.5 foot on each side. For his and the neighbor directly behind him, it's 7.5 on each side, but 25 on the rear. But there's nothing that runs through there. So there's really nowhere else on the property where we can do this.
Okay. Very good. I don't have any further questions for you. Thank you. Be sure and see the clerk to sign in.
Yes, it's fully walled. Yes, you knew that. Okay, thank you.
Is there anyone here or online who wishes to speak in support of this item? Is there anyone here or online who wishes to speak in opposition to this item? No. Okay. All right. Development Services, do you have anything further?
Nothing further.
Thank you. And applicant, did you have anything further you wanted to add? No. All right. Thank you. All right. That will close the hearing then on application 21-0893.
Our next case is item H3, variance application 21-0928. The applicant is Ann Hurley. The request is a variance to access requirements. Staff findings will be presented by Chris Grangelard.
Good morning. Chris Granlenard again, planner with Development Services. We're to present a variance 21-0928. The applicant is requesting a variance to allow a 15-foot easement to serve a proposed 2-lot subdivision of a parent parcel zoned AS1 and ASC1. Per LDC section 6.02.01, a minimum width of 30 feet is required for a proposed access easement that will serve 2 or 3 lots. The applicant requests a 15-foot reduction to the required access easement with width to allow a width of 15 feet to serve 2 lots. That concludes my report. I'll be glad to answer any questions you may have.
Thank you. All right. Applicant, is the applicant here?
Hello, my name is Chad Hurley. I live at 9574 McIntosh Road. I'm representing myself and Ann Hurley, my wife. I'm here today because I'm trying to request this variance to ultimately create an easement to a second parcel that I have. So my wife and I own 2 adjacent properties, and one of the properties is the main parcel that holds the home, outbuildings, etc. There's an additional vacant lot that is a second lot. It's not part of the original parcel, and it has no access to public highway. So there's no access to McIntosh Road. It's essentially landlocked, and it creates an unnecessary hardship for me and my family because it devalues the property because there's no access to it except across the main parcel. So merely I'm requesting this variance to create an easement across the main parcel to access the landlocked parcel. The easement that will be created from the 15-foot reduction on the variance for the driveway will be 30-foot wide, where it's able to be created 30-foot wide to the landlocked parcel. So I'm kind of caught in a catch-22 here because, you know, I've gone through the lengthy process, expense, time, and, you know, I'm not that familiar with this process. And this adjacent landlocked property was deeded in 1989, I believe. So January of 1989. And, I'm not super familiar with Hillsborough County codes, but I believe in July of 1989, they created a code that would not allow properties to be landlocked without having access to the highway. So essentially, I'm trying to ask for and trying to alleviate something that I believe should have already been attached to the property. And now I'm have to go through this difficult process to get something that I already believe that should already been in place. I have a So this is a view of what I'm suggesting. The main parcel is over here where I'm pointing. It's a flag-shaped parcel, meaning it's a giant rectangle with a very small 15-foot drive that goes to McIntosh Road. This is parcel number 2, and I'm suggesting creating this 30-foot easement on the perimeter here to make it to the 15-foot driveway with access to McIntosh Road. Because at this time, this property is land, it has absolutely no other access to it aside from my parcel, which I believe, again, it really devalues my property and just creates a hardship that, something I got to deal with now. Appreciate the time. I think that's it.
Well, first of all, Mr. Olson, is that correct? No.
Mr. Hurley?
Hurley. Mr. Hurley, I'm sorry. I'm looking at the wrong one. Thank you. Mr. Hurley, you own both parcel 1 and parcel 2, correct?
Yes.
All right. So you have access to parcel 1 because you have that long driveway, the flagpole.
Correct.
All right. So you have access. And then because you own parcel 2, you have access to parcel 2.
Correct.
Okay. So you don't have a problem with access to parcel 2?
I do if I want them to be independent.
By independent, what do you mean?
Meaning if I want to sell one or the other, they have to go together.
All right.
So it creates, it devalues the property, something that it doesn't have access to the highway. Now, it shouldn't, I don't believe it should have been deeded that way. This should have been straightened out long ago.
All right. And I may need the county attorney's help on this with some specific questions. But first of all, you're not granting an easement for access to your own property.
Excuse me?
You're in other words, you are not granting an easement for access to your own property because you have access to it, correct?
I have access to it, but I want to create the easement because if there's potentially 2 different landowners, I want there to be an easement to the second parcel.
So the county, of course, I mean, this is a question of access.
Mm-hmm.
And so the variance has to do with the width of the access and.
Correct. I'm showing you the motivation for the request for the variance.
And the variance is just for the flagpole part, right?
Correct. The variance is to ask to have the driveway instead of it. They're calling this a 2-parcel subdivision, which in my opinion, I don't agree with because we're talking about a landlocked property, not a 2-parcel subdivision. But ultimately, the request is to allow the 15-foot driveway to be okay as opposed to having 30-foot wide, because 30-foot wide is just it's not possible.
But, okay. If the county attorney's office is online, maybe you could help me with this a little bit. I guess what's confusing to me is property owner can't grant an easement to themselves. County is not being asked to grant an easement because the county doesn't own the property, so the county isn't granting an easement.
I'm not asking for.
And just a moment, I'm requesting from the county attorney's office to come online. So could someone speak up from the county attorney's office, please? Okay, thank you.
I can hear. This is Cameron Clark. Go ahead. I was listening to how you were laying it out. Go ahead.
Okay, thank you. A subdivision is required here, correct? Because if an easement is granted to access parcel 2, then a subdivision is required. Isn't that correct?
I believe so.
And when I say that, I mean a platted subdivision?
I would, looking at this, I would say that sounds right, yes.
Okay. And since the property owner, same owner, owns parcel 1 and parcel 2, there's really no access. I mean, there is access to parcel 2, so that's not a question or a problem. So I guess that the application itself is maybe premature?
Well, the access issue would have to be addressed during the subdivision process, I believe. But I mean, on the face of it, I certainly agree with your contention that one can't grant an easement to themselves. But if the parcel's split, there needs to be an assurance that there's access to right-of-way for both parcels. And in this circumstance, an easement like that would, I think, be the standard way to do that.
Okay. Mr. Hurley, is there a subdivision application in or a parcel split application in?
No, I'm not asking for that because that would be like, if I can't get a variance on the getting down the driveway, what's the point of trying to create a subdivision? And not to mention, I mean, there are already 2 separate parcels. These are not, they have 2 folio numbers. I'm not asking you to split a piece of property. I have 2 pieces of property.
And the 2 pieces of property are contiguous, correct?
I don't know what contiguous means.
They adjoin each other, they touch each other?
Correct, they're adjacent.
Okay. And you own them both?
Correct.
Do you have either one of them under contract to sell?
No.
Okay. Okay.
Madam Hearing Officer, just to interject, I'm pretty sure, because we've seen property changes hands, and then forgive me because real property is not my primary area, but we've seen instances when property change hand where the easement to access, let's say parcels A and parcel B, there's an easement across parcel A to access parcel B. The easement obviously runs with the land, and so if the property changes hands at some future date, the easement wouldn't be specific to the owner. It would be, I would say, for the owner of parcel B to access that parcel across parcel A. And so I'm not sure. I mean, especially if the lots already have separate folios, it's an interesting question. But I guess the larger question is the ability to grant an easement from parcel for parcel B to access across parcel A, even if the ownership is the same of the 2 parcels at the present time. And I know we've seen instances where property changes hands and the new owner is bound by the easement obligations of the previous owner.
Okay. Thank you very much for that. Mr. Hurley, did you have anything further?
No.
Okay. All right. That's all the questions I have for you. Thank you, sir.
Thanks.
And please sign in with the clerk before you sit down.
Okay.
Thank you. All right, is there anyone here in attendance or online who wishes to speak in support of this item? All right, is there anyone here or online who wishes to speak in opposition to this item? Please come forward. State your name and address, please.
My name is Gerard Van Hook, 9580 McIntosh Road.
Yes, sir, go ahead.
I purchased a property 2.2 acres on McIntosh Road on August 87. It is L-shaped, but basically measures 139 by 543 feet. It has 10 100-year-old grandfather oaks on it. They clean the air that we inhale and provide us with lots of shades. But it occupies 75% of this land at 9580. And it is protected by law. The east side of this land is the only area where I can grow my fruit trees. Orange trees, tangerine, grapefruit, tangelo, and other oranges. It's the only area of my land where I can grow anything because it's where the sun can penetrate my land. The east side became my lifeline. Anything I love grows on the east side. The rest of the 2.2 acres is occupied by the oak trees with their very large shaded areas. I oppose the action that my neighbor is proposing simply because it would just about wipe out my livelihood. The fruit trees that have provided me with a living and my own health, without the east side of this property, it would completely wipe me out. I have to treat those orange trees very gently to maintain them because in my area, most orange trees don't survive. But with the grace of God, I please ask you to stop this action.
Thank you, sir. Is that all?
That's it.
I understand. Would you please sign in with the clerk?
All right.
Hi, my name is Melody Calhoun. I live at 9564 McIntosh. I also own 9562 McIntosh, which is the full 5-acre run that goes up beside the easement. There's currently two 15-feet easements coming in off of McIntosh for this property. A little bit of the history on this property is the gentleman, Raymond Roop, purchased that years and years back. And when he purchased Lot 1, he also increased Lot 1 with a second purchase and then deeded them back together. He purchased this additional triangular piece at a later date. I think they said 89. And it also created a larger lot. Knowing Mr. Roop like I did, he would have gotten it put together, but the gentleman was killed in the no-name storm of the 99s.
Wow.
So therefore, there's this lot, and it has that piece, and that really doesn't affect me. But the 15-foot right-of-way going up the side between our two properties does. If they subdivide this out And the intent is to subdivide it out and sell that lot and make money right now. Real estate is high. And they intended to move. The sales are thought. And so I didn't come quite as prepared as some of the other stuff did, but I do have, let me step to this picture and see if it will this show? How do I get this on?
They'll turn it on for you. Thank you.
All right, this was me building the fence and getting the neighbors to help me down between these two driveways. As the gentleman spoke before me, you can see to the corner right there is the beginning of the corner of their property that Mr. Gerard here was in question about. That is his property that's running north to McIntosh from there. And that line there is the beginning of the Hurley's property now. So we built that fence to divide it because I was having issues with delivery and what have you, running over into my side, breaking down the medians in mine and tearing up my part of their land. So I built the fence. I then had the fence come home twice, 3 times. This post would get run over from their side because they're trying to cut and get out of the driveways in this 15-foot right-of-way. And so they're running over my fences. Now, my husband had a massive ischemic stroke in 2016. They're well aware of that, but they don't fix it, even though it's obvious it happened from their side. So that means their driveway's not large enough, I assume. So that certainly wouldn't be large enough for more residents. This is, again, I fixed it again. And this is how it stands at this moment. This is if you're on McIntosh and you're looking down. The driveway to the right is the 15-foot allowed access for the Hurleys. And if they go back there and they want to add more, then there's going to be additional people all trying to get out that 15-foot. In our county, the garbage cans, I don't know how well you're aware of the dimensions on one of them things, but they're approximately 2 foot by 3 foot by 4 foot tall. Now, when you stand 2 of them into 15 feet, which is a garbage and a recyclable, you've took up a lot of space. Now they want to add additionals back there. Where is that all supposed to come in as well? What would be accommodated by allowing them to get this right away and sell off that separate piece of property because property's high right now? I understand the motivation value for them. That makes perfect sense to me. But the value of the properties and what it's going to do and the hardship of trying to deal with a 15-foot right-of-way that obviously cannot accommodate them is going to be a problem. The other thing I would like to say is if you allow that right-of-way across that property, the 30-foot, anybody is going to build up a driveway. It's wet. Water drains. That goes to a creek if you look at that. And a good deal of that wedge of property is in the creek. So if they try to sell that as a homestead, then it's barely an acre. I don't think it quite is. Where do you put the septic? Where do you put the well? And you are dealing with Baker Creek running through there. These are all my thoughts about the property. It's not the actual deal of them trying to make money. I understand. It makes perfect sense. But they're going to leave, and that leaves all of us a hardship. I don't want to see the property divided. Once again, that's my input to it. We have several people here that are all in support of not doing this. You asked for 2 of us to speak.
Okay.
Okay?
Ms. Calhoun, I have a question for you.
All right.
How long have you been at your property there at 9564, 9562?
My parents bought that in the summer of 1970.
All right. And so then from your knowledge of this property, this triangular piece, before it was owned by the same person, when it was under different ownership, were you aware of how anyone accessed it at that time?
Yes, it came in from McIntosh Road, right at the curves. And they sold off that little back chunk of it for some extra money, and Ray had money. Just as Mr. Gerard's here's property, used to be Ed Morgan owned that property. That property used to run parallel to my 5 acres all the way to the creek. And Mr. Morgan got broke and he sell off part of it, and then he get broke and he sell some more. So that's how those properties got broke.
All right. And so I'm looking at the aerial. I can see the curve in McIntosh Road. And so is it your testimony then from your own knowledge that there was someone had access to that back parcel, which at that time from about where that curve is in McIntosh?
Yes, it
was it owned? Just a minute, please, Ms. Calhoun. Was it, to your knowledge, was it owned by the same owner at that time?
As who?
That back triangular parcel, was it owned by the same owner that had property fronting on McIntosh Road?
I don't know if they fronted. It's that next property forward.
Towards McIntosh Road? Okay.
The address would have been the 9586 now.
Okay.
And I believe that it came from that property is what I believe. But the access comes in off that curve there.
Thank you, Ms. Calhoun. And then you mentioned a creek. What's the name of that creek?
Baker Creek.
Somebody in the audience speaking?
Yes. Can you show this? This was my lookup when I went onto the county site here.
Okay.
And this is the creek that comes through their property.
Okay.
And it runs right along the back through theirs and comes along the back of my property.
Okay.
And you can see that the wedge here is mostly in that water and then comes back out. So it's not even a really good, suitable land space for building. So I don't know about getting a variance for them.
Okay. That's all the questions I have for you now, Ms. Calhoun. Thank you.
All right. Should I leave these pictures with him?
Yes, please, with the clerk here and sign in with the clerk. All right. Are there others in the audience who wish to speak in opposition to this application? There's still 5 minutes and 41 seconds if there are. All right. Don't see anyone or hear anyone. Development services, anything further?
No, ma'am.
All right. Then applicant, could you come back forward, please?
Hello.
Thank you, Mr. Hurley. Have you ever, are you aware of wetlands on this second parcel?
I'm not sure what you mean by wetlands. I'm sure they show a flood zone on the map, but I mean the picture that I saw on the phone is not an accurate description of the property. Baker Creek goes through the very corner, and it rides the perimeter. It doesn't go through the middle of the property, is what was displayed on the phone.
Okay, that was going to be my next question. You're aware of the creek?
Correct. There's
There's another microphone right there
Sure.
that you can use.
Thank you. So they show a flood zone on the partial
Okay.
here, which also goes across, even close to my residence. But we're talking, the creek is approximately in this area and cuts off and rides the perimeter. It does not go down the center.
Okay.
There is no doubt it's wet down there. And if someone wanted to develop it, it would need the proper permitting for drainage. It would need the proper permitting for road base and that to get over that way. There's no doubt. But that, that's step 23. I'm on step 1, just trying to be able to drive down my driveway. If I can't drive down my driveway in relation to this easement, all this other planning down the road doesn't make sense, because this, step 1 is being able to come onto it. If that's my best understanding of it. I don't do this for a living. I'm a homeowner, a pet food retailer. I don't, this isn't my forte. I'm just, muddling through it. So.
I understand. All right. I don't have any further questions for you. Do you have anything else you want to add to the record?
Yeah, I just wanted to address, some of my neighbors' concerns. I apologize that, everybody had to take up their week and come out here. I appreciate you coming out and sharing your thoughts and ideas, and, bring, even some new thoughts that have been brought up that maybe I didn't think of before. I mean, as far as my neighbor to the west of me, Mr. Gerard, I'm sorry if there's a misunderstanding. I'm not asking to encroach on his property or ask for any of his property or anything like that. I'm merely suggesting I want to drive down my driveway, and of course there'd be additional vehicles. So that's there's additional vehicles, there's additional road base if I would create the easement, which is another step. But I'm not asking to damage his trees, widen the fence. I'm not asking for any of that. So I'm not sure if there's a misunderstanding there, but I do apologize. As far as my, I guess that's all I wanted to add.
All right. Thank you, Mr. Hurley.
Okay, thank you.
Madam Master.
Yes.
Yeah, I'm sorry.
One moment.
Sure.
I just want to clarify in our staff report. This is parcel 2 of this is actually a pre-existing, a pre-69 lot. So, and the notice on this was regarding the easement requirements to serve that lot, but it's not technically a subdivision because, as the applicant has pointed out, it is a pre-existing lot. Now, the nature of the variance and the root of the variance is exactly the same, the width of the easement on the flag stake to serve a second lot. But to correct the staff report, this isn't technically a subdivision because, as a lot created before July 26, 89, it is a lot of record. So just want to clarify the point that it is an existing lot of record that is landlocked, and it does require county review to grant the access through the, some sort of access, but it is not technically a subdivision as stated in the staff report.
So
Referenced in the staff report.
thank you, Mr. Hisney. So if Mr. Hurley, the current owner, were to sell that lot, that triangular shaped lot, to another party, and if he were to grant an easement to access it, the county, as far as it being a pre-existing lot, would recognize it as a buildable lot. I mean, not even taking into consideration wetlands or not, but
yeah. Well, we would recognize it as a lot that is potentially eligible for building permits. But as with any lot, we never say a lot is buildable.
Okay.
Because at this level of review, we don't know what the situation is with the wetlands, uplands, or anything else dealing with the property as to whether it's actually buildable or not. But as far as it being eligible for building permits, yes. However, it does not have access, and then that's what this request is for: is to grant access to it through an easement, the width of which on the flag stake will not meet county requirements for that easement width.
thank you very much. Understand.
So, for example, even if, let's say, I wanted to sell the main parcel, and the second parcel, if I wanted to hold on to that, maybe I want to rent it out or graze animals there, or I'm not saying that's my intention, but if that was something I was wanting to do, I wouldn't have access over the parcel 1 because, I wouldn't have it anymore. So I'm putting myself at a disadvantage, and that's all I have.
All right. Thank you, sir.
All right. Thank you.
All right, that closes the hearing then on application 21-0928. We're going to take a break of, Mr. Hisney, do we typically take a lunch break? We have 4 applications left.
That is entirely at your discretion, ma'am.
Okay. 2 are together. All right, we're going to take a short break then, and we'll come back and plow through the lunch hour. Hopefully we can do that. So 5 minutes. We'll be back at 12:09.
Hello, I didn't get a chance to test my microphone earlier. I just want to make sure that I can be. estimated height in order to allow a 6-foot high fence within the required front yard on the north side of the property along Windhorse Road. Thank you.
All right, thank you. Is the applicant here?
Good afternoon. Colin Rice, 101 East Kennedy Boulevard, Suite 2800, here on behalf of Matthew and Casey Olson. Mr. Olson is present here today, and I'll be presenting on their behalf for this application.
Thank you.
Sorry. What's up? Okay. Okay, so thank you to Mr. Ball for the introduction. We are requesting a variance to the maximum height for the front yard of actually two properties here. The next item on your agenda is related, and you'll see how they fit within the broader context. But really the idea is to build a consistent 6-foot high fence bordering 3 properties under Olson family ownership. This is an overhead visual of the Blake Tree Lane address. That's the subject of this application, so you can get a context for where it is and how it's configured. And this is a portion of the survey submitted with the application. Our subject property is here with the yellow star. The next case is to the immediate east, 1415 Humphreys. And the idea is where the red line is depicted to have a consistent 6-foot tall iron masonry fence. Of course, they'll go through permitting subsequent to this determination. With respect to the Blake Tree Lane property, the property is shaded in purple here. This is not to scale, but at the top left corner of the property line in red is just to give you an idea, the only portion of this lot that's not currently entitled to have a 6-foot fence. The yellow line depicts the distance from the front of the structure to Windhorse Road. It's over 250 feet. So in practice, while this corner represents the front yard for fencing purposes, it really functions more like a side and rear yard. Further, Blake Tree Lane itself is, per land development staff, categorized as an ingress egress easement, not a street. So the majority of that western property line is already entitled for 6 foot. And this shows in dark red where there's already a prevalence of 6-foot high fences or walls along Windhorse Road. So it's certainly in keeping with the character of the neighborhood. Of course, here is your next item, which we would intend to have a 6-foot fence as well. So this circle, this absence here, is the only portion that's really under consideration for this application, is entitled for 4 foot, and we're seeking 6 feet. So in the interest of time and brevity, I will refer you to our submitted narrative with the application for detailed analysis of the hardship criteria. But we'll hit some main points here just so you have a thorough understanding. So with respect to hardship and practical difficulties, this is a very uniquely oriented property. The structure is very, very far from Windhorse Road. Again, Blake Tree is designated as an ingress-egress easement and not a street. And again, the portion in question here really functions more akin to a side and rear yard, which already would be entitled to a 6-foot fence. It wouldn't deprive rights commonly enjoyed by other property owners. We've gotten broad support in the record for this application, 6 letters in support in the record for your review. To my knowledge, no opposition to this. So it will benefit the Olsons by having this consistent fence to buffer and screen and beautify their property. And it will just stay consistent with the development patterns on Windhorse Road and for the neighborhood.
Could you go back just one second to the properties, nearby properties that have 6-foot high fences along Windhorse?
Sure. Again, approximate, just to give you an idea.
And so those across the street on Windhorse, are those 6-foot high fences in the front yard or the side yards?
Side or rear.
And the property to the east,
this one?
That one and one more over. So the one more over to the east, take your pen and put it one more over, or the other way for you. Yes, there you go. Is that a side yard?
This is, these are rear yards.
Okay.
Along Windhorse. They enter through Oakrest.
All right.
And this is a side rear yard.
All right, thank you. And then the one that's to the east, but just adjacent to this one, is that the one that is part of the next application?
Exactly.
Okay. Is that a front yard?
Yes.
Okay. All right, thank you.
Okay.
Go ahead then, please.
So just running through the remaining points we have, there is no substantial interference. Again, all of the adjacent neighbors are overwhelmingly in support of this project. It is in harmony with the land development code. As we had alluded, this really functions more akin to side and rear yard. We have the unique orientation. This is not the result of any illegal act. There's been no code enforcement case. There's no fence constructed. Nothing of that sort has predicated this application. Substantial justice being done. I mean, we are seeking a taller fence, but I think that in this instance, with these orientations and the overall goal and benefit to the community, that it's justified. Again, these letters are in the record in support, just to give you a sense of the good work they've done in the neighborhood and the good neighbors that they are and will continue to be. And again, just in conclusion, we think this is a much more harmonious proposal than having little chunks of 4-foot fencing. We respectfully request your approval. Happy to answer any questions that you've got.
Could you just address if, I mean, compliance with the code would mean having a 4-foot fence there. Yeah. And so why is that impossible or not desirable, or what is the problem with putting a 4-foot fence there?
Partly aesthetics. It would just be a cut down 4-foot, turn the corner, go back to 6 feet. It just doesn't provide the same degree of protection and buffering and aesthetics that really is appropriate for this project within the context of, you know, these are all Olson properties. Mm-hmm. And the idea is to kind of have them in a cohesive family community, for lack of a better term. It just makes more sense from a design and practicality standpoint.
And the display you put up a moment ago that had the circle that showed where the area in question is. Mm-hmm. Okay. From that circle, then going east, are there, well, going, I guess, that way to me, that way to you?
This way?
The other direction.
This way.
Yes, please. So going in that direction along Windhorse, are there 6-foot high fences on both sides of Windhorse?
Yes, that's what the dark red depicts, existing right. 6-foot. It's okay. Fences and walls, but the height is there.
Okay. All right, thank you. Okay. That's all the questions I have for you.
Thank you very much.
Thanks.
I'll submit this to the record.
Please. All right, is there anyone here or online who wishes to speak in support of this application? Don't see anyone. Is there anyone here or online who wishes to speak in opposition to this application? All right, don't hear anyone. Development Services, do you have anything further?
Yes, I just want to clarify that the required front yard, 25-foot front yard on this property, extends for the entire frontage along Windhorse Road. And so if they want to have a 6-foot high fence in any part of that required front yard, that it does require a variance. The one graphic that was presented made it seem that the variance is only applicable or sought for the northwest corner of the property. I would like for him to clarify whether the intent is to have a 6-foot high fence across the entire frontage, which is my understanding of what it was. And if so, then the variance is needed for the entire frontage, not just for the northwest corner.
Colin Rice again for the applicant. That's correct, and I thank you for pointing that out. The red line in the survey depicts where we intend to have a 6-foot fence.
So it's the entire frontage on Windhorse Road.
Exactly. It's demonstrating the portions that aren't entitled right now. I apologize if that wasn't clear.
I'm not sure that's still clear. So are you saying that there are some portions of this property, the frontage on Windhorse, that are already entitled to 6-foot high fence?
Yes, because Blake Tree is technically the front. So is that not true? May I ask Mr. Hisney to just clarify?
Sir, because Blake Tree is an easement, it doesn't constitute a street. So this is not a corner lot. If this was a corner lot under the code, then there'd be a little bit of a different situation, but this is not a corner lot per the code. So you have one required front yard, and it's the northernmost 25 feet along the Windhorse Road frontage. So the variance is needed for the 6-foot high fence all the way on the Windhorse frontage, and then the first 25 feet down Blake Tree is where you need the variance for.
Okay.
Okay. Which was my understanding of our understanding from the application.
Okay, understood. Just so long as it's clear that they intend to have the 6-foot across the entirety of the Windhorse frontage and Blake Tree.
And is there a fence there at all now?
No, there's no fence there right now.
All right.
Okay.
Thank you.
Thank you.
All right, that closes the hearing then on variance 21-0998. Next case.
Next application is item H5, variance 21-0999. Applicant is Donald and Sharon Olson, and they are requesting a variance to fence requirement. Staff findings will be presented by Sam Ball.
All right, thank you. Sam Ball, Development Services. The applicant is requesting a height variance to install a new 6-foot fence on a residential RSC4 zoned property. According to section 672C1A, fences over 4 feet in height shall not be allowed within required front yards in residential districts except under specific conditions, which in this case do not apply. The applicant requests a 2-foot increase to the maximum permitted height in order to allow a 6-foot high fence within the required front yard on the north side of the property along Windhorse Road. That concludes my report. Thank you.
Thank you, Mr. Ball. All right, applicant, please.
Hello again. Colin Rice for the applicant. In this case, the Miss Sharon Olson is here as well, owner of this property. I'll be brief because there's some overlap, but I'll point out the differences with this application. Okay, so same as the previous application, we're requesting for approval for 6-foot high fences in required front yards of this property. Just an overhead visual again, we're just to the east of the Blake Tree property. The main difference being that the structure here is constructed in the 1960s and is incredibly close to West Windhorse, whereas the Blake Tree structure is extremely recessed within the lot. Again, same concept, red line equals 6-foot fence throughout. The portions wherein 6 is not permitted, that's where we're seeking relief. So to give you an idea, the Windhorse front door is along Windhorse. The access is through the driveway to the west and into the side and rear of the home. Just to orient you. And Windhorse Road is categorized as a collector road within Hillsborough County, which tends to be a more medium intensive traffic type road than a local road or street.
Mr. Rice?
Yes.
That microphone there, could you just pull it a little closer to you when you speak, please? Thank you.
Okay. So The Brandon area in Greater Hillsborough County has expanded considerably since 1960. So as constructed, this house was closer to a much less intensive street upon construction. So the intensity had proliferated and come up to the point. I don't know when this was categorized as a collector road, but as it sits today, this is one of the few homes that does actually front within close proximity to Windhorse. The surrounding properties, again, as you can see the demonstration through the dark red lines, there is a prevalence of 6-foot fences within this region along Windhorse. So again, with respect to this particular application, it is, through no fault of its own, now closer to a far more intensive street than land development code and comprehensive plan contemplate for future development. We'd like to see that this proximity be more akin to side and rear yards or recessed further. Again, prevalence of 6-foot fences and walls along Windhorse. We have the same degree of support from the community for this application as well. There's no opposition. No legal act preceded this application. Again, here's the list of those who have submitted letters in the record in support of this application. And again, we respectfully request your approval. There's more detail in the variance criteria within our narrative submitted. I'm happy to answer any questions, and I'll submit this into the record.
Just again, please clarify what type of fence is going in here? This is approved?
No permit has been applied because we need variance relief prior to permitting application, but it will be a masonry and iron spaced out fence. It won't be a masonry wall, so there will be airspace and transparency.
And that's, okay, that's it. That's all the questions I have. Thank you.
Okay, thank you so much.
Mm-hmm. All right, is there anyone here or online who wishes to speak in support of this application? Is there anyone here or online who wishes to speak in opposition to this application? Okay. Development Services, do you have anything further?
No, ma'am.
Okay. And applicant, did you have anything further you wanted to add? No. All right, thank you. And so that will close the hearing on application 21-0999.
Our final variance today is item H6, application 21-1014. The applicant is Bradley Hermans. They're requesting a variance to Brandon Main Street regulations found in part 312, and also to variance to guardhouse and gate requirements found in section 60303. Staff findings will be presented by Israel Monsanto.
Good afternoon, Israel Monsanto Development Services. The applicant is requesting variances from the Brandon Main Street development regulations found in Land Development Code section 31200. The applicant had originally requested a variance from section 60303, guardhouses and gates. However, transportation staff advised the applicant that the type of variance for that requirement does not apply to the loophole process. Therefore, that request has been withdrawn from the variance application. Deviations to that code section are handled as administrative variances, which are reviewed and approved by the county engineer. So the parcel is located at the northeast corner of Lakewood Drive and Morrison Road in Brandon. The site is within the TC2 sub-district of the Brandon Main Street and is currently vacant. The applicant intends to develop the site with a new office building. The project will be fronting an A street, which is Morrison Road, and would have access from Morrison Road to meet code site access standards. As proposed, the project site layout would not meet the minimum building frontage percentage, parking location for sites along A streets, and the building type compatibility requirement found in the Brandon Main Street development regulations. All other requirements from the Brandon Main Street will be met. The variances requested are three total. The first one is variance to the off-street surface parking location to relocate the off-street surface parking areas in sites within an A street frontage building. Therefore, the off-street surface parking lot would be located to the side of A street frontage building and will front an A street Morrison Road to the south. The second variance is to building frontage requirements, in this case along Morrison Road, and the variance is to reduce the building frontage percentage by 19%, which will be resulting in a building frontage of 56% of the project's A Street frontage on Morrison Road. The requirement is 75% minimum. And the third variance being requested is to building type compatibility for buildings in the TC2 district. The variance is to eliminate a separation by a street shared alley service, parking drive, or pedestrian way, a minimum of 25 feet in width, from adjacent dissimilar building types, and this is along the north and the east. If the variance is granted, this would result in a site with no street, shared alley, service, parking drive, or pedestrian way provided along the north and east adjacent to dissimilar building types. And this concludes my presentation.
All right, thank you. Is the applicant here?
Good afternoon. My name is Jesus Murley. I am at 12506 Bronco Drive. The owner, Bradley Harriman with Suncoast, and our architect here, Robert J. Lentz, are here to also address any questions. I'd like to start out by showing you the site plan. If I could use this Elmo here, correct?
Yes.
Can you hear me?
Yes.
Great. Is this microphone okay?
Mhm.
There I am. Okay, so the fundamental driver, if you would, oh, let me start with the background, I'm sorry. Suncoast Community Health Centers is a 501(c) federally qualified community health center. They've been in operation in Hillsborough County since the 70s, and they've been acting as a partner with Hillsborough County really since that time, and they've worked together with the county to provide COVID testing and COVID vaccination and other adult care centers. They have a terrific relationship with Hillsborough County. And so this project really is an extension of their administrative facilities to make that healthcare outreach more efficient. That's what's driving this. Approximately 3 parcels to the north, less than 500 feet away, is their headquarters in Brandon. And so in keeping with the Brandon Main Street overlay district's intent of having a pedestrian-friendly community, this will provide that, especially when we have some pedestrian traffic along Lakewood. As Israel said, we are at the corner of Lakewood and Norwood, and that's really the driver of this site plan, if you will, is that access is not being allowed off of Lakewood Drive. We had consultations with transportation staff, and they were of the strong opinion that that would be a safety hazard because of the separation between, I know Israel said Morrison, there's a little bit of description on what the name of this road actually is, Norwood Lane, but it's the southern road. There's not enough separation distance between Norwood and the distance here. So that's what's driving our frontage reduction on our access. We're having to push our access all the way to the east. And what we're trying to do to mitigate for that frontage requirement is proposing a facade wall to extend the view of that building. And I'm going to show you a rendering, which we've also have displayed over here. And that facade wall is over here on this side. And so our access would be underneath a beam, if you will, through the building facade to give that appearance of over 75% frontage requirements. Since our access has to be on that side, again, the driver of that, we need parking for our facility, obviously. So that's why the parking is going on that side. We are proposing an L-shaped building. Really, we're extending frontage along Lakewood and Norwood Lane. We're almost being a complete or exceeding the Brandon Main Street, if I could say, because of our extensive frontage requirements that we're trying to do. We have to put our parking lot there, or else we just can't provide enough building square footage, really. So that's the driver for the compatibility of variance. That I believe that was variance number 3. compatibility or separation, because that property to the east is residential and the property to the north is residential. So instead of having a 25-foot shared alley or street or service or parking drive, we're really having a parking lot. Not really sure the distinction. I believe the parking drive might be the center aisle, but regardless, it's consistent with having a alley as having paved parking lot. I believe it would be actually less intrusive to the adjacent neighbors because there won't be any driving right adjacent to their houses, which would be the case for an alley. So we addressed the frontage and then the off-street parking lot, the location of that. One of the other items that we're talking about, and Israel touched on his presentation, was the gate that got removed from the variance requirements. The intent of the gate is to, again, give that appearance of a continuous facade, the gate being here. I understand that the separation distance from that and the edge of the pavement is what was a concern, and we're understanding that that's not going to be addressed through the variance. But we felt like the gate was important because what we're having is an L-shaped building, which at the end of the day, it encloses all visibility from the frontage roads. A passing patrol car will not be able to look into that, and that might be a difficult, potentially a zoning requirement with CPTED design, crime prevention through environmental design. It's not. We feel like a gate is almost imperative, if you will, for security purposes. So. Those are the reasons for our variances, and overlooking, and again, going back to the rendering, which part of the Brandon Main Street requirements are specific building design elements, and that's why we have the architect here. But we also, there's a building very similar to this, just to the north, as I mentioned, their clinic, and this is going to be compatible with that. So it'll have a continuous look and branding, which is important to the Suncoast Community Health Centers and Hillsborough County as part of through their partnership. I believe that does it. I'm available to answer any questions.
Just some questions. I'm curious about the history of this property, just looking at some of the street views on Google Maps.
Yes.
It appears there was an access point already that's probably pretty close to Lakewood, if I'm looking at the right property. Was there some former use of this property?
Former.
Mm-hmm.
Yes, it was. The use currently previous to the vacant lot was a beauty salon, like an independent, maybe teaching and maybe doing some services. I believe it might have been a residential unit that was converted to that. But it has been demolished. The previous one was not. Yeah, we have the old survey. Thank you, Robert. So, sorry, changing microphone.
Oh, I see.
This was the previously building, and they had parking here, and really a carport there. So because the building looks centered, I'm just assuming that it might have been residential use, but that's all been demolished, and currently, I'm not sure what street view you're looking at. However, it's currently replaced with a gravel stabilized parking area. Currently, it's functioning as a excess parking area for the Suncoast Clinic just to the north.
And on that survey, it does look like there's the access point sort of
on here,
I guess, to the west. And then there's another access point. Is that about where the access point is going to be for this new building?
Yeah, that's a good point. Well, the access for the new building is pushed a little bit further to the west just because we need space for the water meter assembly and we'll have, you could tell the radiuses for turning and entry movements, exit movements are a little bit easier to maneuver for a vehicle.
I see. I don't have any further questions for you right now.
Okay.
Thank you.
Thank you.
All right, is there anyone here who wishes to speak in support of this application? Anyone here online? Okay. Anyone who wishes to speak in opposition to this application?
Sir, I need you to sign in, please.
Oh, please sign in with the clerk over here. All right, thank you. Development Services, do you have anything further to add?
Madam Hearing Officer, I would like to clarify something. For the wall along the south that may extend for the gate, we advise the applicant that any fence or wall that would extend past the building facade will have to be no more than 6 feet high. Anything higher than 6 feet would require an additional variance. So for the looks, it will meet the intent, but for the purposes of actually being built, they could have a gate and a wall, but it has to be no more than 6 feet along that facade. Other than that, that's all I need to add.
All right. Thank you. Applicant, did you have anything further? And would you, regarding that height that Mr. Monsanto just mentioned, anything on that?
We're not in opposition to that. Yeah, we'd keep it to 6 feet. And Israel may correct me if I'm wrong. I think we needed to have it 11 feet back. Is that right? Because it's 10-foot setback, so it needed to be out of the front yard. So we would be actually setting that a little further, beyond the facade wall. We would be fine with that.
Okay, thank you.
Thank you.
All right, that closes the hearing then on 21-1014.
All right, well, that concludes the variances and then takes us to section J of the agenda, which are special uses. The first item, J1, that case was continued at the beginning of the hearing to the October Lujo hearing, which then takes us to item J2, special use application 21-0897. The applicant is Mark Bentley. The request is for a special use permit for a professional residential facility, Recovery Home A. Staff report and recommendation will be presented after the applicant's presentation.
Good afternoon, Ms. Hadley. My name is Mark Bentley, 401 East Jackson Street, Tampa, 33602. I represent the property owner. Before you start the clock on me, I've got some exhibits I wanted to hand out. Okay? Thank you. Specifically for you, there's a book of composite exhibits that I intend to go through occasionally, and also 2 written statements from Tamara Schwartz and Dr. Megan Carmen.
Okay.
And they are originals. That's the only one I have, clerk. So. The client is seeking a special use permit to allow a professional residential facility.
Mr. Bentley, I'm sorry.
I'm sorry.
If you just bring the microphone down, please. Thank you so
Yeah.
much. Thank you.
One of the hazards of being short. But they're seeking a special use permit to allow a professional residential facility, recovery home type A, having a maximum of 8 place residents at the home. The county's professional planning staff, which will render their opinion subsequent to my presentation, has rendered an opinion that, its professional opinion that, quote, the proposed facility is consistent with the requirements of LDC section 6.1.75 and therefore compatible with surrounding residential development. Note that under Florida law, a special use, it's also known as conditional use or special use, has a presumption of being a permitted use once it is determined by substantial competent evidence adduced at the hearing that it complies with all provisions of the Land Development Code and the Comprehensive Plan. The evidence in the record indicates that the application meets all code requirements. So the burden is on the local government once we meet our burden to demonstrate compliance with all special use criteria to demonstrate that it doesn't comply with the code requirements, which in this case, obviously, the staff has a different opinion and determined that it has. And they have to do that by substantial competent evidence. The planning report was rendered by AICP Colleen Marshall, who's very well qualified. Accordingly, based on the professional staff report, our client is entitled to the issuance of the special use permit. And with all due respect, there is no legal basis or any discretion that the hearing officer would have to deny the permit. I'd also point out to you on tab 4, and I know you're familiar with a lot of these cases, Ms. Hadley, but one of the key cases, and this is the Irvine case, this is where the Florida Supreme Court adopted the dissenting opinion of Judge Zemmer in the first DCA, and specifically had notes 2 and 11. I won't read those. I'll just take a look at 11. It says, quote, in determining whether to grant an exception, which in that case it was a special exception, which is tantamount to special use, the Planning Commission is required to base its decision on specific standards and criteria set forth in the zoning regulations, and is reversible error to base a decision on other grounds. And I'd also like to point out, this is even more legal on point, as the residents who are undergoing treatment for drug or alcohol abuse are considered impaired or handicapped under both the Fair Housing Act and Americans with Disabilities Act, and cannot be subject to disparate treatment unless the local government can provide a compelling governmental interest in providing them disparate treatment. Also, drug or alcohol addiction is defined as a disability under Section 504 of the Rehab Act and Section 1557 of the Affordable Care Act, which prohibit discrimination based on the resident's disability, including treatment in a supervised drug rehab program. So the intent of Hillsborough County's cap on the number of residents allowed in a single-family district is to emulate the activities and impacts that would be generated by a typical single-family use. I'd also note, interestingly, the transportation comments, which are in your backup, indicated that there's going to be a reduction in traffic, equivalent, I think, 7 daily trips and 1 p.m. peak. So based on compliance with the LDC standards, it will be virtually impossible to distinguish this home from any other single-family home in the community. I'd also like to point out there is a major change in the law this last legislative session. The state policy of integrating recovery residences is so important that the legislature intervened and passed a law stating that for purposes of building code occupancy classification, recovery homes are considered single-family or duplex. This eliminated the arbitrary and confusing application of fire code, often characterizing recovery homes as multifamily or hotels or motels. And that's on tabs 10 and 11, that information. Now what I'd like to do is present the testimony of our expert planning witness who has over 35 years experience. He's testified in numerous administrative and legal proceedings. That's Mr. Russell Ottenberg. And then after Mr. Ottenberg, Dr. Lawrence Wilson, the director and operator of 7 Summit Pathways, who will be operating out of the property. Thank you. Russell?
Good afternoon. Russell Ottenberg, 3737 Lake Joyce Drive, Land O'Lakes, Florida, 34639. I have not been sworn.
All right, would you raise your right hand, please? Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
I do. Thank you.
Thank you.
The special use criteria for professional residential homes in Hillsborough County is very clear and very precise. I'd like to go through just a portion of my my report, which is included in the binder that Mark submitted. The first criteria is that no such use, in this case, a professional residential home type A, shall be established within 1,200 feet of another such use or a community residential home type B or C. There are no other type B or C community residential homes in the specified radius, nor another professional residential home, professional residential facility, so that criteria is satisfied. No signage identifying the facility shall be permitted beyond the name of the facility on the mailbox. That is being complied with. There will be no signage on the facility, just the mailbox. In all professional residential facilities, for the purposes of calculating density, each place resident in the facility shall equal 1/5 of a dwelling unit, except in certain districts. The facility may have up to 5 placed residents and any caregivers, caregiver relatives, or facility workers occupying the facility, which meets the minimum requirements of the district. However, each additional placed resident require additional land area to satisfy the 1/5 requirement. In this case, the subject property consists of 0.65 acres, more or less, zoned RSC 6, which provides up to 6 dwelling units per acre. Using a gross density calculation of the 0.65 acres, 6 dwelling units per acre, 5 residents at 1/5 each per dwelling unit would allow theoretically up to 19.5 residents, say 19 per code. That's roughly 2.5 times what is being proposed as part of this application. The next criterion is each facility shall provide a buffer and screening area as required by section 60606 of the Land Development Code. Alternative screening can be proposed. However, in this case, the proposed use proposes the screening that is under 60606, and thus it meets that criterion. Finally, I'd like to put a picture up on the overhead. Recovery homes shall be designed and built to appear similar to a residential structure as possible. This is a photo of the home. Clearly, it is a residential structure. There's not going to be any other construction, so it meets that criterion. In summary, the 5 criterion, each of them has been met as required. We have a staff recommendation or a staff finding of consistency. It is compatible with the underlying land use, so it's consistent and compatible. Staff is recommending approval on this, and that is the conclusion of my presentation. I'd be happy to answer any questions you may have.
All right, thank you. I don't have any questions for you. Thank you.
Thanks. Wilson, would you please come up, state your name and address for the record, please?
Mr. Bentley, just a quick question for you. Back to the microphone, please.
Sure.
Thank you. Mr. Ottenberg said his report is in the record. Is that in the binder?
Yeah, I think
Do you know which? Okay, I'll find it then. That's all right.
it's tab 1, and he's
Okay.
got a lot of exhibits and photos.
Tab
and
1.
things like that.
And one more thing. These letters that you provided, you said these are the originals?
Correct.
Okay, so I'm going to give them to the clerk to scan in, and they will put them in the record and make sure I get them.
Okay, great.
And these are from neighbors?
They're from former, or people actually underwent the program.
Okay, I'll hold them till the presentation's over.
Okay, thank you.
Thank you.
Dr.
And
Wilson?
if the speakers could come over and sign in when they're done speaking.
Yeah.
Thank you.
Good afternoon. I'm Dr. Lawrence Wilson. I live at 18306 Bankston Place in Tampa. I presently serve as the medical director, sole physician, and CEO of 7 Summit Pathways, a substance abuse treatment facility here in Tampa, specializing in treatment of licensed healthcare professionals. Our facility is certified by the professional health monitoring programs sanctioned by the respective boards, licensing boards in the state of Florida. Our patients, almost 95%, comprise physicians in practice, dentists in practice, psychologists in practice, pharmacists, and students in those professions, as well as any other licensed healthcare professional. Most importantly, the majority of our patients are nurses in the state of Florida. Nurse practitioners, certified registered nurse anesthetists, registered nurses, and licensed practical nurses. Our patients are referred to us respectively from their monitoring boards. We are deemed a certified professional health monitoring program. Evidence-based medicine has demonstrated the significant improvement in the level of treatment when patients in those professions are surrounded in the treatment process by their peers and where they live with their peers. Our living situation is consistent with their expectations of what they're used to at home. These are highly educated, well-motivated, financially stable individuals who go back to supporting family situations, supported housing, and the majority still have employment. Their employers refer them to these monitoring programs due to substance abuse issues and possible impairment. Our program is specifically designed for these professionals. They are constantly under our care for 24 hours a day, 7 days a week. They have no access to their own personal transportation. They have no access to their finances. They do not have credit cards. They do not have cash. They do not have any other means of accessing their funds. In addition, they have very, very limited electronic communications. Our patients do not have cell phones. They do not have laptops. They are monitored and observed 24 hours a day by not licensed, but by trained behavioral health technicians. Our success rates are far superior to most substance abuse treatment programs because of the high motivation of our patients. They cannot return to practice until they successfully complete our program, and they agree to this with their monitoring programs. Once finishing completing...
Excuse me, sir, would you please pull your mask down?
Okay.
Thank you.
Once completing our treatment program, they cannot return to work until we give the approval to their respective monitoring programs that they are safe to practice. Once completing treatment, they are then extensively monitored under monitoring contracts with their respective monitoring programs for 5 years with extensive substance abuse and alcohol testing and a host of other requirements in order to ensure they are safe to practice continually. Evidence-based medicine demonstrates when these professionals complete this mode of treatment with this expertise and then are monitored for 5 years, long-term abstinence from substances of abuse and alcohol is greater than 90%. I'll be happy to answer any questions you may have.
Sure, Dr. Wilson. How long do your patients typically stay in this treatment?
Typical treatment is individualized. Typically, it's 30 to 90 days.
I see. And in this scenario, when the individuals being treated are in this facility or in this home, what is their typical routine? Are they walking in the neighborhood? Are they out?
They cannot leave the facility without accompaniment by a behavioral health technician. We provide all transportation from the home. They come to the treatment center approximately 8:30 in the morning. They are there all day. They do not leave until approximately 4:30 in the evening. And then they go back to their residence where they are monitored. They attend meetings such as AA or NA. They have requirements, they have assignments that they have to work on, and they do not leave until the next morning when they're transported by us the next day.
I see. So they don't actually live at the home. They just visit the home every day.
No, they live, they reside in the home. They have their meals in the home. They sleep in the home, but the actual treatment is performed at the treatment center.
I understand.
This is just their residence.
Okay.
But the residence is monitored 24/7 with in-house staff in attendance at all times.
So there's in-house staff and the patients live at the home, they sleep at the home and so forth. So when they're living in the home, then they're free to walk in the neighborhood, go outside or swim in the pool.
They can swim in the pool. They cannot leave the premises unless they leave with an attendant.
Okay. Okay. I understand. All right, that's all the questions I have for you. Thank you.
Certification.
Our home is presently being certified by FAR. FAR is the state's accreditation for any type of sober living house that has to meet certain requirements, have certain resident managers in place. We are Joint Commission certified. I don't know if that you understand Joint Commission. Joint Commission is the federal accreditation process for all healthcare facilities in the United States. We are DCF licensed. We pass all audits and inspection with flying colors. Anything else I need? No. Any other questions I can answer? I'll be happy to.
Residents in this home, and I understand they're being treated for substance abuse. Is there any screening, for example, criminal background check and things like that?
Well, only by their history. if they had a criminal background, it would have been handled by their respective licensing boards,
Understand.
who monitor all licensed individuals on a frequent basis, reviewing criminal records.
Thank you. Thank you very much.
While you brought that up, Ms. Hadley, in tab 2,
Dr. Wilson?
when you get the opportunity. Pardon?
Oh, Dr. Wilson, please sign in with the clerk over here, please.
What I was just going to mention briefly, when you get the opportunity under tab 2, I have an article. It's the positive effect of mutual help recovery homes from the Journal of Community Psychology, published 2007. Amongst the conclusions are homes are a deterrent to crime, as the residents must maintain positive behavior and are often excessively vigilant. That same article deals with this issue that comes up a lot on these NIMBY issues about property values. Extensive study, there's no diminution of property values as a right result of a recovery home being in a residential neighborhood. And quite frankly, you would not be able to distinguish this home from any other home in the neighborhood because of the limitations and the conditions the county imposes on it. So that's all I have right now.
Mr. Bentley, oh, yes, Dr.
I'm board certified by the American Board of Addiction Medicine. I'm clinical faculty at the University of Florida and the University of South Florida in addiction medicine. And our facility is one of only 4 or 5 approved and certified professionals program by the professional monitoring programs. So most of our patients come from all over the state of Florida and obviously need supportive housing when they're here.
A question, and probably Dr. Wilson, you could answer this one. When the individuals who are living in this home are picked up daily to go to a treatment facility, is there, for example, one vehicle that picks them all up, or is there repeated trips?
No, we have two spanking new 15-passenger Ford Transit vans, and we have an 8-passenger Honda Odyssey van. One trip.
Thank you.
That about covers it right now. And I guess on rebuttal, then if you have any more questions or concerns, and here again, I know I imagine some of the issues that are going to be raised, and I've dealt with those, I think, to rebut those with either what I'm going to give you in the booklet or just my testimony. Thank you very much. Appreciate it.
Sir, thank you. All right, is there anyone here in attendance or online who wishes to speak in support?
Madam Chair, Mass.
Oh,
Staff.
Development services. Okay,
And
I'm
Mr.
jumping
Bentley?
ahead. Development services.
Mr. Bentley, I need you to sign in, please.
So yes, as explained by the applicant's representatives, this request is for a professional residential facility, recovery home type A. Maximum 8 place residents be located at the corner of Alder Way and Brandonwood Drive. I'm just going to very briefly go over the staff report since it was described in good detail by the applicant. I would like to point out Mr. Ottenberger in calculating the permissible number of residents on this site, which is derived from the property zoning, the size of the property, and then a 5 persons per dwelling unit density calculation, so that this site could accommodate up to like 19 residents. And while that's theoretically true based purely on the calculations, I'd like to point out that in actuality, 9 or more residents in a professional residential facility would actually constitute a recovery home B or C, both of which are prohibited in the RSC 6 district. So the 8 residents that are proposed are indeed consistent with the density calculations for this project, but is in fact the maximum number of residents that could be considered for a professional residential facility on this property. As detailed in the report and Mr. Ottenberger's presentation, the site as proposed, or the facility as proposed, would comply with the requirements of Section 61175 in the Land Development Code, which regulates professional residential facilities. Based on the evidence and statements they've made in their applications, it would comply with the sign requirements, buffering and screening, residential appearance, parking, etc. We received no objections from any reviewing staffs, including transportation, EPC, and water resources. And so staff finds that the facility, that a professional residential facility, recovery home A, is consistent with requirements of the LDC and therefore compatible with surrounding residential development. However, in the statements from the applicant regarding the off-site provision of medical and treatment services, when this application first came in, it stated that those services would be provided off-site. Staff immediately advised the applicant, in that case, this does not constitute a professional residential facility as regulated by the Land Development Code, that the code requires the treatment and medical services to be provided on the premises. There were some subsequent discussions with the applicant. Ultimately, the applicant's representative indicated that the use of the property would comply with the requirements of the Land Development Code or something to that effect. You will find then that in the recommended conditions of approval, because of the initial representation in the application, that condition 1 states that the facility shall provide board, lodging, supervision, medication, counseling, and other diagnostic or therapeutic treatment services to the residents. The medical and treatment services shall be provided on the premises. So the statement from the applicant that those services be provided off-site is not consistent with professional residential treatment facility under the LDC. That would conclude my comments.
Can I just clarify that? And
I think, well, yes, please. Go
Okay.
ahead and address it now.
I think Dr. Wilson testified as to the treatment at the facility. There's going to be counseling, medical treatment, et cetera, et cetera. There was some confusion when we initially filed the application, okay? But there will be medical treatment, okay? And mental health treatment and medication dispensed at the facility. So we meet the definition as required under the professional recovery.
All right. I may have more questions for you on rebuttal, but
Sure,
thank you
thank
for
you.
that.
Hi, my name is Megan Lassiter Carmen. I'm a physician locally. My address is 4623 West Browning Avenue. I've
One
not yet
moment,
been
please.
sworn.
Do we have planning commission weigh in on these?
I'm sorry, yes, ma'am. Planning Commission staff does make a recommendation on
Okay,
this. Sorry
one
for
moment,
that.
please. Planning Commission, we'll hear from Planning Commission first. Ma'am, are you speaking in support?
Support.
Okay, so just stand by just a moment, please. Thank you.
Hi, good afternoon, Madam Hearing Master. This is Jillian Massey with Planning Commission staff. The subject site is in the residential 6 future land use category and is within the urban service area. It's also within the limits of the Brandon Community Plan. The proposal meets the intent of Objective 1 and Policy 1.4 of the future land use element of the comprehensive plan by providing a residential support use within the urban service area. The proposal meets the compatibility requirements of Policy 1.4 as the predominant character of the area is single-family residential dwellings at comparable densities, and the special use is proposing to convert an existing residential dwelling rather than build a new one. The subject site is located in the residential 6 future land use category. The subject site zoning district is residential single-family conventional 6. A professional residential facility / recovery home type A is a residential support use that is a permitted use in both categories. According to Objective 9, Policy 9.1, and Policy 9.2, the proposed use must comply with all local, state, and federal land use regulations and comply with all requirements for the operation of a professional residential facility. The applicants agreed to comply with all applicable requirements and therefore meet the intent of Objective 9 and Policies 9.1 and 9.2. Objective 17 and Policy 17.1 permit the development of residential support uses in all residential future land use categories. The subject site is in the residential 6, as I mentioned, and is therefore permitted. Objective 20 and Policies 20.5 and 20.6 support the development of congregate living facilities within unincorporated Hillsborough County, subject to the limitations. The applicants demonstrated that no existing facilities are within a reasonable distance to prevent excessive concentration. There are no existing community residential homes type B or C within 1,200 feet of the subject site. There is also no licensed group homes within 1,200 feet of the subject site. The applicant's proposed density of 8 beds is comparable to the density permitted in the surrounding area. The proposed special use therefore meets the intent of Objective 20 by providing innovative housing for all residents of Hillsborough County. The proposed special use is also consistent with the Brandon Community Plan and the Livable Communities element of the comprehensive plan. It meets the intent of Goal 5, Strategies 3, 4, and 5D, which require each of the character districts to follow a specific development pattern. The subject site is in the Suburban Character District, which is predominantly low-density, single-family residential in character. Based upon those considerations, the Planning Commission staff finds the proposed special use consistent with the future of Hillsborough comprehensive plan for unincorporated Hillsborough County, subject to the conditions proposed by Development Service Department. Thank you.
Thank you, ma'am. Mr. Hisney, did you get finished with Development Services report? You might have gotten cut off. I'm sorry.
No, ma'am, I was done. Thank you.
Okay, thank you. All right, so proponents now. Are there any persons here or online who wish to speak as proponents in support of this application? Yes, ma'am. I need your name and address, please.
My name's Dr. Megan Lassiter Carmen. I'm at 4623 West Browning Avenue, Tampa, Florida, 33629. And I'd like to speak in support.
All right, thank you. Do you have any details, please?
Sure.
Go ahead.
So I'm a local emergency room physician and have been so over the last 10 years. I'm also a mother of 4 and have been in the Tampa community for over 20 years. About a year ago, I found myself struggling with the disease of addiction, and that had been kind of a slow progress over a couple years previous to that. And like my story, like many others, it started with a routine surgery, complicated by personal struggles and eventually a pandemic. Fortunately for professionals like myself, there is a program that we can either be referred to or that we can call. And I got to the point in my life where I was ready and I picked up the phone and called the Professional Resource Network. Fortunately, they were able to send me for evaluation and subsequently treatment. And I just like to emphasize that although it took some convincing on my half, I truly believe that addiction is a disease. And just like any disease, people deserve treatment for this. I spent over 90 days at 7 Summit Pathways. And I have to say, not only did they save my career and my family, but my life. And so I've been back in the community now, working in the trenches in a large local ER, and have been successfully completing my monitoring program. I've been a better friend, family member, wife, and mother than probably I ever have been before, because treatment provides a lot more than just substance abuse, but helps you find balance. You know, this is an illness of the soul. But you know, it's true what he said. When we enter the facility, we relinquish pretty much everything: our car keys, our transportation, our finances. We're supervised 24/7. You know, we stay at that facility in the evening and we're with techs there all the time and with other peers, mostly medical professionals. And in the morning, we are driven over to the treatment center for cognitive behavioral therapy on top of multiple other different resources for treatment, and go back in the evenings really just to eat, sleep, attend our meetings, and prepare for the next day.
Is that it? Thank you. First, thank you for having the courage to come and share that, and it's very valuable testimony. Question for you: during your treatment, during your stay at the facility, was there any medical or psychological treatment that you received at the home?
So
and don't describe the treatment, just basically yes or no.
I mean, yes, most of us have antidepressants or some type of sleep medication or something like that that we're on that would have to be administered at that time of night.
Okay. Were there medical professionals there? Licensed medical professionals treating people there, not being treated?
So, I mean, I've saw a doctor would come by, you know, on multiple occasions and see us over the weekends and assess us depending on what stage in treatment we were at.
Okay. So there was treatment going on at the home, not just the treatment facility, but at the home where you stayed at night and,
I mean, medication administration if needed.
okay.
And then we did, meetings as far as NA or AA every evening, and we did our assignments. So all that's kind of part of the comprehensive treatment program.
I understand. Okay. Thank you very much. That's all the questions I have for you.
Okay, I included a written statement as well. Thank you.
Did you sign in with the clerk? Thank you. Are there any other persons who wish to speak in support of this application?
My name is Tamara Schwartz, 12826 Sorrento Way, Bradenton, Florida, 34211. I'm speaking in support. My name, like I said, is Tamara Schwartz. I'm a certified registered nurse anesthetist. I also have a master's in military psychology and soon to be mental health nurse practitioner. I also received treatment at Seven Summit, and I was actually in treatment for 9 months. During my time there, I'm going to back up. I feel very passionate about defending them, and I'm going to get emotional. I think there is a stigma, I'm sorry, on what addicts look like. Everybody thinks addicts are criminals that live under a bridge and that they're non-productive members of society. And that's just not true. While I was in treatment with pilots, with lawyers, with nurses, with doctors. But most importantly, I was in treatment with human beings. Without these programs, we would be dead. I would be dead. Without him, I would be dead. When I came to treatment, I had given up on myself. I came in after a suicide attempt. I didn't have hope. I didn't believe in me. Dr. Wilson did, and his staff did. I was very sick when I came in, and I required a lot of treatment and a lot of supervision, and that was done by medical professionals, by nurses, by behavioral techs, and by Dr. Wilson himself. I had to be checked that I didn't need to go to the hospital because I was that sick. And that is why I was there for so long. I'm obviously back in my community and I'm back giving back. I'm changing careers so that I can give back. And I just think it's really important to remember that we don't devalue a neighborhood. We are people with a disease, and this is an insidious disease, a disease that nobody wants. And like Megan said, many of us, this comes from having surgery. I had a big surgery that I had complications. I was in the ICU for 2 weeks on continuous infusions of pain medications and sedatives, and I woke up an addict. And I didn't seek treatment because of the stigma on mental health and addiction. And it escalated to this point. And like Dr. Wilson pointed out, this was a facility I was sent to by my professional organization. The American Association of Nurse Anesthetists sends us to this facility. The nursing board sends us to this facility. And there are very few that they allow us to go to. And they are very strict, as you can imagine, because they are concerned about the safety of the public. And they want us treated properly and by the proper professionals. And I apologize for being so emotional, but that's how important this program is. So
Thank you. Ms. Schwartz, a question for you also. Again, thank you for your courage to come forward today. Just basically yes or no, at the home where you stayed overnight, did you receive medical treatment there at that home or any treatment at that home?
yes.
Okay, thank you very much. Please sign in with the clerk before you sit back down. Anyone else who wishes to speak in support of this application? Okay. Anyone in attendance here or online who wishes to speak in opposition to this application, please come forward.
Let me adjust the mic if I can. Can you hear me
Please.
okay?
Yes.
Okay.
State your name and address,
Right,
please.
my name is Jeff Skloot, 1904 Alder Way, and that is in Brandon. And I just want to say that the opposition is not towards treatment or anything towards addictions becoming, again, viable, part of the community. That's not the issue in my opposition. I do want to thank the people that showed up here today from two communities, one Brandonwood, one Sunny Hills, and anybody that happens to be virtually attending, and also people that have submitted emails and letters to show their opposition. Now, according to the Hillsborough County Property Appraisers Database, the residence located at 1313 Brandonwood Drive was purchased on January 31st, 2020 by Samuel Ball and Elizabeth P. Oliva. Samuel Ball is the Director of Maintenance for Seven Summit Pathways Treatment and Recovery Center located at 1910 Orient Road, Tampa. And Elizabeth P. Oliva is a corporate member of Multiple Innovations for Recovery, which is the parent corporation for the DBA Seven Summit Pathways. By February 2020, it appeared that the residence at 1313 Brandonwood Drive was being operated as some sort of halfway house or treatment facility based upon the business description of the parent company and Seven Summit Pathways, plus the observed vehicular traffic, including large passenger van activity with people disembarking, carrying luggage and tote bags at the house, and personnel coming and going wearing medical scrubs. Neighbors became suspicious but were apprehensive to contact the owners concerning the usage of the residence. Again, the residence was purchased by employees and not Seven Summit Pathways or the parent corporation. You must ask yourself why. Our guess is to deflect liability claims against the parent corporation or Seven Summit Pathways should the circumstances arise. And please note the following. Cars parking on the street block traffic and obstruct vision for cars turning left or right onto Alder Way from Brandonwood Drive. Employees ignore the stop sign at Brandonwood Drive and Alder Way. They just blow right through it. House individuals have loud conversations in the driveway after 11:30 at night while on smoke breaks. Sometimes this occurs after midnight. Residents have been observed walking through the neighborhood, but we don't know if it was supervised. There are two instances of neighbors' mailboxes being run over by their vehicles. The mailbox was replaced on both occasions. However, of the observed van usage, one van was a Honda minivan and the other van is a 12 to 15 passenger van. Question is, are they commercially insured? Do their 15 passenger van drivers hold a minimum of a hack license? On February 18th, 2021, a complaint was filed with Hillsborough County Codes Enforcement. Case number CE 2100-2158 was opened. On February 23rd, 2021, the complaint was investigated. Codes Enforcement indicated that Heather Brown from Seven Summit Pathways said to the investigator that 1313 Brandonwood Drive was not a residential treatment facility. No medical treatment was administered. She indicated that 8 to 11 occupants, other than employees, spend the night. Furthermore, she said in part that the business did not apply for a variance due to COVID-19 and would have their attorney look into it. Furthermore, she said, turns out that Seven Summit Pathways was licensed for treatment by the Florida Department of Children and Families. That license was for 1910 Orient Road only. The license did not cover 1313 Brandonwood Drive. They were cited by codes on approximately February 24th for improper zone use. Indicated reinspection would take place 15 days later. On March 2nd, 2021, a resident at 1313 Brandonwood Drive packed her bags, threw them under the bushes on Alder Way, then went to the next door neighbor at 1311 Brandonwood Drive and told that resident she was being held against her will and to call 911. Hillsborough County Sheriff's Department did respond. There are small children at 1311 and other residences on Brandonwood Drive and throughout the subdivision that could be at risk when a resident decides to leave the house. Additionally, Schmidt Elementary School is within a half a mile of 1313 Brandonwood Drive. On March 17, 2021, Codes Enforcement indicated that Ashley Phillips, on behalf of the company's attorney, Mark Bentley, has requested an extension to comply until April 4th so they can apply to become a community residential home type A. Please note that they did not submit the application within 15 days of the requesting the extension to do so and would be cited accordingly. They were given an additional 15 business days to comply. At that point, a codes hearing was requested. The company's attorney stated that the current occupancy of the dwelling had been reduced to 5 residents in keeping with the 11th District Federal Circuit Court ruling during 2004. That was Jeffrey O. versus the City of Boca Raton. The additional residents would be placed at their other home located at 1602 Lark Lane, Brandon. Again, there is no way to confirm this was done. The case law indicated that dwelling units which meets the housing needs of recovering drug addicts and alcoholics and do not provide on-site addiction treatment on the premises may not be regulated more stringently than any other dwelling units. Subsequently, they can operate a sober living house within the RSC 6 zone as a single-family dwelling with no regulations, licensing, or oversight. It was described that it is no different than renting out 5 rooms in the house to unrelated people. Under the circumstances, I don't view it that way. I'm sorry, but to me, that's apples and oranges. Again, there is no way of telling or verifying how many occupants reside there, and are they only housing substance abuse patients? Prior to then, they were also housing people with mental disorders. On May 3rd, 2021, the Hillsborough County Fire Marshal's Office cited them for 3 violations. As of August 1st, the requested codes enforcement hearing is still pending. A sober living home, which they're operating currently, the definition is cut and dry. However, a professional residential facility is much more complex. Please note the following definitions. Sober living home is an alcohol and drug-free living environment for individuals for no more than 5 people in recovery who are attempting to maintain abstinence from alcohol and drugs. These homes are intended to act as supportive housing environments for recovering addicts. Addiction treatment services do not take place at the home. Rather, the residents obtain drug and alcohol treatment at a separate facility. If addiction treatment is provided on the premises of the residential home, the property would be subject to land development regulation and licensure as a regulated treatment facility. As this residence is currently not regulated, and considering everything that has transpired to this point, are you supposed to take the word of the company that no treatment was occurring? Professional residential facility type A definition is any residential establishment other than a hospital or nursing home providing board, lodging, supervision, medication, counseling, or other diagnostic or therapeutic services to a maximum of 8 persons not related to the owner or operated by blood, marriage, or adoption.
Sir?
And in need of a structure.
May I interrupt you just a moment?
Sure.
Are you speaking for a number of people, or are there others who wish to speak today?
Well, there are more that want to speak. Well, and take me off the clock just a second here, if you would, because they said, go ahead with everything that I have. If there's time left over, they will talk. And I'm assuming that if they don't have a chance to talk, they'll be able to submit their comments via email too.
I know it's too late for that. How many people here wish to speak in opposition? Would you stand up, please?
I can tell you
I see about 6 people, and there's just a little over 6 minutes left.
their comments are not as long as mine, but I would
I
like,
understand, but there's 15 minutes allotted to the opposition, and that should be distributed among all who wish to speak.
I have some very important things to cover here.
How much longer do you have, sir?
Maybe 3 minutes. I'll speed it up, okay?
All right. Those here who wish to speak in opposition, do you want this gentleman to speak for you? Do you just want to put your names in the record, or do you have things that you wish to say? Raise your hand if you wish to say something on the record.
3 people, so I'll speed it up.
So can you sum up in about 2 minutes, please?
Yeah, absolutely. I might be able just to cut to the chase, okay?
You can submit your statement.
I intend to.
Well,
all right.
Here, yes, you can submit your statement to the
Yes,
record.
written testimony can be submitted after.
Yeah, absolutely.
Yes,
And I
ma'am.
wanted everything that I said to be entered, okay? In closing, the owners of 1313 Brandonwood Drive purchased the property solely as a business and leased it to the place of employment. No consideration was given to the nearby residents as to what this may do to the neighborhood and property values. Allegedly, the residents is utilized to house people with substance abuse and mental disorders while they undergo treatment at 7 Summit Pathways. The problem is they set up shop without notifying Hillsborough County or applying for any licenses, permits, or oversight from the state of Florida. They did this for 16 months. Subsequently, they garnered unbridled profits just the same. And basically, that's all I'm going to say right now. And I thank the Land Use and Development for letting me speak today.
Thank you. Register over here, please, and put your statement in the record. All right. Please come forward if you wish to speak in opposition to this application. And state your name and address, please.
Hi, my name is Donald Rick. I live at 1308 Wallwood Drive in Brandon. And I've not been sworn in.
All right, please raise your hand. Do you swear or affirm that the testimony you're about to give today is the truth, the whole truth, and nothing but the truth?
Yes, I do.
Thank you.
I'll just make a quick statement. I would like you to take into consideration that this is a 5-bedroom residence we're talking about. They want to house 8 people overnight in this 5-bedroom house. This house also is on currently on septic as well as our neighborhood. And I believe that that is not going to be sufficient to house and bathe and have 8 people plus staff have correct facilities, and that the septic is not designed to have that many people. That's a statement I want you to consider. Thank you.
Thank you, sir.
Any question?
Please sign in with the clerk. And if you're speaking in opposition, come on forward. This is your time.
Hi, I'm Michelle Davenport. I live at 1307 Brandonwood Drive. I am opposed to this because we have a lot of children on that road, and not to discredit their professions as addicts, but we and our children do not need to be responsible for their recovery. And them living there is going to affect our community one way or the other. I also represent, and speaking for my mother, who is the president of our association, she has signed a letter of appeal here as well. She's just not here because she's sick. So with that said, I'll just go ahead and swear in because I did not swear in.
Please, a question for you. There was apparently this home or this facility has been operating. How has it affected you so far?
It's just left us very unnerved and nervous as to what are we going to expect every night. If they're not supervised and they decide to leave, are they going to knock on my door and scare my children and alarm our whole household, which can happen? I mean, they can walk out the front door anytime they want. They're not handcuffed. They're not, strapped. Nobody would want that.
Okay.
And that's my main concern. We don't know what to expect because they are not exactly stable.
Okay. Thank you very much.
Okay.
If you have something written there, please submit it to the record.
I do.
Thank you. Any others in opposition, please come forward.
I have not been sworn in.
Okay, raise your hand, please. Do you swear or affirm that the testimony you are about to give is the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Greg Brown, 2203 Wallwood Place, Brennan, Florida, 33610, or Thrive 10. I'm just retired 5 years ago from the Hillsborough County Sheriff's Office as a colonel of patrol operations, and have dealt with homes like this in quite a bit of area. But to say I understand the concept here because I started the crisis intervention program for the Hillsborough County Sheriff's Office, was on numerous state boards. The problem is that these are not residents that you want next door to your children or grandchildren. We've had increased calls for service as a result of this facility even before we knew it existed. And on top of that, none of the people that spoke already in favor of it, of course, they're going to come up and rebut this, but none of them said these are such a safe location that they put next to their home or their grandkids' home or anything like that. These do result in increased calls for service. Kids should not have to see people being flicked off. One of the residents stopped to look at this facility before they knew really what it was, and one of their residents in training, or one of their customers, was standing out in front giving the finger to the individual. This is not the type of facility that is closely monitoring their recipients, the people that need the help. They're not being monitored close since they can escape, and they'll knock on doors at night trying to get in and saying they're being held as kidnapped victims. I'm going to defer the rest of the time to someone else.
Thank you, sir. Please sign in with the clerk.
Yes, sir. Yes, ma'am.
My name is Kathy Skloot. I live at 1904 Alder Way, Brandon, Florida. I live directly across this street from the house. They say that they are guarded 24/7. I have photos of them out smoking, walking. I don't know if they're accompanied by anybody, with the back door open. I have some health problems. My husband and I are getting ready to downsize. Who's going to want to buy my house with a facility across the street? Mrs. Casso, who lives in the neighborhood, has a house with a variance behind her that is not being used. There's a house that they're trying to get the variance on directly in front of her. This will make the third house in our neighborhood with a variance. We need help. This is our neighborhood. Thank you.
Ma'am?
Yes, ma'am.
Do you mean you know of 3 other treatment facility homes?
There's two other homes, one on Rockwood. There's one on Sunny Hills Way. And there's
Samuels?
Sunny Hills.
Oh, Sunny Hills.
There's a variance on a house on Estatewood that is not being used, that it will go with the house for the rest of the time the house is there.
And you know that these are approved for treatment?
I don't know what
type
they're
homes?
approved treatment for.
But you're saying that they're some kind of variance or special
Yes.
use for treatment facilities?
Yes, ma'am. 3
Okay, and
in our neighborhood.
when you say in your neighborhood, how close to this property do you would you
Within
say that?
1,200 feet of this property, there'll be 3.
You're sure they're within
Yes,
1,200?
ma'am. Would you, my husband has the exact feet.
Do you have the addresses?
Yes, he does. I don't have them on me. He has them.
Okay, is he here?
Yes, ma'am. He just
Okay.
spoke.
Okay, oh, okay,
And so does Mr. Wells.
okay. All right, thank you. Would you sign in with the clerk, please? Yes. Yes, sir.
Hi, I'm Joseph Wells. I live at 1301 Estatewood Drive. I live very close to this house. Been a resident of the neighborhood for 37 years. I've raised my kids. Most of the people in the back are in opposition of this. We all live in the neighborhood. Most of us have been there for well over 30 years. I want to state that the group that wants this home, the ones sitting up front, not a one of them have clean hands. Not a one. They snuck into the neighborhood, backdoored everybody, ran for months before we figured it out. And then when we did, now we want to go get licensed. We want you all to approve our actions. I find that despicable. They're a lot of brain power. They're real smart. They've got a lot of attorneys. We're homeowners. We've got grandchildren. My grandchildren live in that neighborhood now. It's very scary. I have been out walking in the morning, and I've watched residents unsupervised. If they're not unsupervised, both of them sure acted on multiple occasions, smoking, walking up and down the road. We have a number of neighbors with Ring cameras finding people in the backyard in the wee hours of the night. Not sure they're residents. This has all come about in the last year or so. Again, not a one of this brain power here has clean hands. They ought to be ashamed of themselves. Not a one of them live in our neighborhood. Thank you, and I appreciate it.
Thank you, sir. Please sign in with the clerk right here.
Yes, my name is Dr. Stephen Amy. I'm an acupuncture physician, nationally board certified that works with the federal government, specializing in pain management, traumatic brain injury, and spinal cord injury. I deal a lot with people that have SUDS, substance abuse disorder. And what comes with that is a very high chance of relapsing. I'm concerned being a homeowner living at 1311 Estatewood Drive that they might come by, if someone will break in my car, try to break in my house, knock in my house, 1 in the morning. Statistically, people that have addiction issues, there's a relapse rate of up to 85%, typically between 40 and 60%. I understand that these are medical professionals.
1 minute, please.
And earlier, the gentleman spoke that they're only treating providers. Well, the other lady that was a nurse anesthetist said there was pilots there, lawyers, and all these other professions. So it's not only medical providers. And I have empathy for that. I'm a provider myself, but I have to worry about the house that I bought. I bought the house a little over a year ago. If I would have known that there was a drug rehab place going on there, it would have definitely impacted my decision, not only on how much I would offer for the house, but maybe I wouldn't even offer anything at all because I don't want that near my children. Thank you.
Thank you. All right. Are there any other persons in opposition who wish to speak? All right. Thank you. Okay. All right. Development services. Anything further?
Yes, with regards to presence of other types of homes in the area, under the code, a professional residential facility must be located at least 1,200 feet from any other professional residential facilities and 1,200 feet from community residential homes type B or C. And then the applicant submitted licensing data from ACA, DCF, and the Agency for Persons with Disabilities. And based on our review of that, it showed that the facility complied with those. Now, our review of the data did find that there were indeed 2 type A community residential homes, and those are ones with 6 or fewer residents, and they are located on 1307 Rockwood Drive and 1410 Sunny Hills Drive. So it appears that perhaps as the 2 homes that was referenced by Mrs. Skloot. However, the separation requirements for a professional residential facility do not include separation from type A community residential homes. Just wanted to point that out from the licensing data.
Thank you. All right, applicant rebuttal. And Mr. Bentley, in your rebuttal, I would like for Dr. Wilson to describe specific treatment that occurs on site, the specific types of licensed persons who are on site. I would like for you or others of your team to discuss how this home was used before the special use permit was applied for and why. Also, describe the number of bedrooms and baths and whether there are licensed or trained staff that remain on site overnight.
Okay.
I'll address the,
And adjust the microphone, please. Thank you.
okay, since you gave me a shopping list here, maybe I'll have some time to talk about something else.
I'll grant you another minute or so if you need it.
Okay, thanks. In terms of required separations, here again, Tom had just alluded to that. Page 2 of the staff report, the only substantial competent evidence you have in the record that meets the separation requirement is on page 2 of the staff report, and the documentation we supplied the county from ACA, DCF, and the Agency for Persons with Disabilities, confirming no other professional residential facilities. So I think we resolved that. In terms of the code enforcement matter, what happened is when they purchased the home, they started using the home, did not provide any medical treatment at the home. They had roughly eight people at the home. I got involved, and then the county cited on, I think, February 18th, more or less of 2021, cited the property owner for zoning violation, unauthorized group home, okay? So what I recommended to the client till we go through this process, and it did take a while because of COVID to get my professionals and surveys and stuff like that, is that the Hillsborough County's definition of family is 5 unrelated persons. I said, reduce the occupancy from 8 to 5, okay? Function as a single family till we go through the process. Hillsborough County Code Enforcement agreed and held the case in abeyance. They're monitoring what's going on. They have copies of the application, et cetera. Also, I point to your attention, I think it's the last exhibit in the binder. The fire marshal had come out, and then that's his fire report, is that we were in compliance, okay? So I think that resolves those.
Okay.
And then in terms of Dr. Wilson, if you want to address you wanted to know.
What treatment exactly occurs on site?
Okay. State your name and address again, Doc. Yeah. What happens there? What happens outside?
Okay. Dr. Lawrence Wilson. Anything else?
Nope.
I need to say?
Yeah, that's good.
So at the facility, patients are evaluated by myself or my nurse. I will do sometimes a physical exam.
One second. When you say at the facility, we're talking about the home.
At both.
The house.
At the
I want to
house.
know what happens at the house.
At the house, if somebody's having a medical problem, I have to come to the house and see them. We will do vital signs. We will take temperatures, blood pressures, check their heart. They have prescribed medications, which we do not dispense. We observe administration. So the patients are responsible for taking their own medications, but it is under the observation to ensure they are taking the correct dose, no more, no less, and that they are taking it, and it's all signed for and observed by a behavioral health technician. I'll very often make rounds on the weekend just to make sure everybody is doing well. I will check somebody, talk to somebody if I think they're having issues. As far as therapy, because of COVID, they are just doing Zoom things because they can't come to the facility, which is just unfortunate right now. So that's on Zoom. Meetings, groups at the facility, if they're on quarantine, I'll do on Zoom from the home. Anything else that we do?
The personnel on site at the home.
Are behavioral health trained by our director of nursing, behavioral health technicians.
Do they stay there overnight?
Yes, they do. There is 24/7.
Okay.
And the whole entire house has 7 video cameras that the tech is also observing, and it's all recorded should there be an occurrence.
Are there video cameras for the outside as
Yes,
well?
there are.
Okay. And these individuals who are under treatment, if they go for a walk outside, do they have to be accompanied by staff?
They are supposed to be accompanied by staff, or at the minimum, they can't go more than 100 feet with another patient. So they do go outside to get air, but they usually go to the backyard.
Are you aware of the incident that was mentioned earlier where someone said that they were being held against their will?
Yes, I'm aware of it. You know, she was not being held against her will. This was her idea of getting out of here. And the police came and did nothing. And she came back to the treatment center.
All right, thank you, sir.
What was the next question?
Mr. Bentley, yes, if you could address the number of bedrooms, the number of baths, and the objection I think that was raised was whether the number of those was sufficient for the number of people, including staff and patients.
Okay, I'll bring up Heather, address that. Heather Martin with 7 Summit. But here again, with all due respect, we're getting a little far afield. The issue is whether or not we meet the criteria here,
That's
not whether or not we have X amount of bedrooms. That's not in the code at all. But Heather, can you state your name and address and respond to that, the number of bedrooms and
Yes, hi, I'm Heather Martin, and I live at 8606 Magnolia Street in Gibsonton, Florida, 33534. And there are, do you want to know the number of beds or bedrooms? 5.
Are you an employee or you're a staff member?
Yeah, I'm a staff member.
And you work at the home with patients or?
No, I'm more administration, so I'm not.
So
I do more a lot of the licensure and things like that.
Okay. And you said there are 5 bedrooms?
Yep.
And how many baths?
There are 4 bathrooms.
Okay. Thank you. That was my question.
Okay, thank you.
Okay.
Ms. Martin. Just come over here.
Please just sign in with the clerk. Thank you.
Okay, this will be my minute, I guess, if you don't mind.
Yes.
I appreciate what the neighbors are saying. I think there's some tension there because of our client going in there. They weren't providing the medical services, but they did have unrelated people there, and I think anyhow we got off to kind of a bad start, and there was some tension on both sides where there's some, I'll just leave it at that. So in any event, I mean, what they're trying to do is they've dealt with the fire marshal. They're dealing with code enforcement. We've got that under control. We did the right thing. We filed the application. They're getting the certification from the Florida Association of Recovery Residences, which is like the gold standard. They're working on that right now. So the home meets all the LDC requirements based on professional opinions of county staff and our expert witness. Therefore, with all due respect, there's really no discretion not to issue the permit. This is reinforced by the case I mentioned earlier, the Irvine decision. We have met our burden of proof, and therefore the permit must be issued. Also, the home will further county and state policies, will provide positive social support, community integration, educate the community about this stigmatized population, and allow patients
Go ahead,
to be treated in a familiar surrounding. And then just one thing.
Bentley. 1 minute.
Okay. The tab 3, a POPCA case, objection of a large group of residents does not constitute substantial competent evidence. And this is not a popularity contest, and factual testimony must be based on substantial competent evidence. The one gentleman who said there have been calls for service, there was nothing submitted in the record. That's just conjecture and speculation. The Blumenthal case at tab 7, citizen testimony must be fact-based. You can't opine on crime or property value if you're not an expert, but you can on factual issues, as you know, Ms. Hatley, like flooding, view, and things like that. So in closing, thank you very much for your time and consideration. We believe we met and fulfilled all the requirements of the code based on 2 professional staff opinions. If you have any questions, I'll try and answer them. You probably don't. So I think that would wrap it up.
I think you answered all my questions.
Thank you very much. Have a good day.
All right. All right, this closes the hearing on application 21-0606. And this closes our meeting for today. Thank you.